But that's okay. Doesn't matter. Well, hello everyone. We are waiting on our good friend to pop on in, and that is going to be Sprinkle Donut. But as I wait on her, I'm going to pull a little bit up. Today we're going to talk about Timmy Jones Jr. He is a monster that took all 5 of his kids' lives. He told the cops that when his hands would not fit around the baby's necks, he had to get a belt to do the job with. And I don't know how you can take all of your children's lives at the same. I don't know how anybody can do that. That is a monster. That is a monster. So we're going to talk about his case today because he has appealed his case, as they all do. He, of course, hang on a minute. He tried to use that he was insane when this happened. He was not insane when this happened. No, he wasn't. So but they're always going to try that kind of thing. Let me pull this back up over here, and I'm going to read you a little bit of something about this guy. Okay, stop it. My dog is down there barking now for some silly reason. Okay. Whoops. Okay, we get this to pull on up, and then we'll get started. I hope everybody had a wonderful afternoon yesterday afternoon. Oops, come on now. Here we go. Now, let's go. Okay, here is the story. I'm just going to read this story, and then we'll go back and we'll get the rest. I'm going to pull his appeal up. We're going to watch the oral arguments and things of that nature. Now, his name is Timothy Ray Jones Jr. He was born December the 28th, 1981, is an American convicted mass murderer who killed his 5 children. Mara was 8 years old. Elias was 7 years old. Nathan was 6 years old. Gabrielle was 2 years old. And Abigail Elaine was 1 year old. And they lived in a mobile home along the South Lake Drive in Lexington County, South Carolina. Jones admitted to working Nathan to the death and killed the other 4 children in a panic. When he says working them, he would make them do PT. So I don't know if you remember this case or don't remember this case, but he would make them do PT, right? Jones pled not guilty by reason of insanity, but the court rejected his plea. He was found guilty of 5 counts of murder in 2019 and was sentenced to death. As of 2022, which is the last update on Wikipedia, he was awaiting execution on death row in South Carolina. The South Carolina Supreme Court denied his appeal. So, we do have oral arguments. We do have the case to look at. And I'm going to tell you right now, it is very, very trigger warning. It is hard to watch, extremely hard to watch. So let me go pull this up over here. We're going to show you a little bit of what went on in this trial for Timmy Jones Jr. I started watching it on day 1, and I wanted to follow it all the way through so I'm telling you, the mother of these 5 children, although they were not married, the mother did not have custody. He had custody of the children. That mother, I don't know, she could not hold herself together in court to even testify. It affected her. This was all of her children gone at once. So it's horrific. So that's the trigger warning on this case. So let me just pull this up. This is going to be from News 19. I got to change my thumbnail for some reason. Put the wrong person on there, but we can always fix that later. That's fine. So we're going to pull up the Timothy Jones Jr. trial. There's 45 different. Hang on a second, guys. Now, this is going to be from News 19 WLTX, and this, I believe, is going to be the opening statements. No, this is going to be the verdict. We're going to watch the verdict because we don't have time to watch the whole trial in this period while we talk about this case. So this is going to be when he has read the verdict in his case. So let me get this ready to go. Let me get my News 19 WLT. Let me put them over here. So credit to News 19. Okay, here we go. Okay. It's News 19. What's it? WLTX. All right, WLTX. Hang on. Ship WLTX. All right. Okay, there we go. Let me get this there. Okay, now we're going to put this over here where it goes. Show that right there to give full credit to News 19. And we're going to watch the oral argument. We're going to watch his verdict being read to him. Get ready. Here we go. Open this up. I'm going to get this started. Well, wait. Okay, yeah, here we go. We'll get it going here. Is it going? Come on. And let me share my screen.
Zero 190 0191 0195, the state versus Timothy Ray Jones Jr. We, the jury, unanimously agree on the existence of an aggravating circumstance. 2 or more persons were murdered by the defendant by act or pursuant to one scheme or course of conduct in the murder of a small child under the age of 11 or younger. And it is so signed by the foreperson. We, the jury, in the above entitled case, have found beyond a reasonable doubt the existence of the following statutory aggravating circumstances, to wit, 2 or more persons were murdered by the defendant by act or pursuant to one scheme or course of conduct, and the murder of 5 children 11 years of age or younger. Now recommend to the court that the defendant, Timothy R. Jones Jr., be sentenced to death.
Okay, that was the sentencing and his trial.
Joy Lord.
I believe not going over. Hang on just a second, guys. Let me see what we got here. Now, I'm going to stop this, and we're going to come over here and we're going to talk about this for a second, because there's a lot to this case, a lot to it, because not only do we have the man getting the death penalty, 5 children that are gone, a mother that's so distraught, but we also have a problem with social services. The mother filed wrongful death suits against the social services because they did not help protect her children. So there's a lot to this case, a lot of things went on, and it's a lot to talk about. So with that is, I don't know if we can do it in one setting. We might have to do it in 2. I'm not sure yet. So hold on just a minute. Get your snack, get your drink, and have a seat, and let's just get into it. If you get a chance when you come in or out, please hit that thumbs up button. That would be just beautiful. We would appreciate it. So we can pull this back up on my little screen over here. Whoops, got to put the right name in there, else it's not going to pull it back up. There we go. All right, we're going to read our fair use disclosure. So let's get started on that. Fair use disclosures. This broadcast may contain copyrighted material, including news clips, courtroom images, documents, photographs, and commentary used for purposes of criticism, commentary, education, reporting, and public discussion under Section 107 of the U.S. Copyright Act. All opinions expressed are alleged claims, legal analysis, or commentary based on publicly available information and court records. This content is not intended to harass, defame, or target any individual. Viewer discretion is advised due to the discussion of violent crimes and legal proceedings. So here we go. We're going to get busy with our opening for the Timmy Jones Jr. trial, death penalty, appeal, and the oral argument. So we are discussing one of the most disturbing family annihilation cases in recent American criminal history. This case of Timmy Jones Jr. A South Carolina jury sentenced Jones to death after the prosecutor said he murdered his 5 young children and transported their bodies across state lines before dumping them in Alabama. Now, there's other parts to this as well. He also went to Walmart and bought supplies to mutilate their bodies with. I'm telling you, it's horrific, and there's a lot of trigger warning here. We're going to examine, here we go. We're going to examine the appeal arguments, claims involving mental health and his mitigation, whether appellate courts could overturn any part of the conviction or the sentence, and the broader debate surrounding the death penalty in America. Now, you know I'm a proponent of the death penalty, and some people just deserve the death penalty, period. And I'm thinking, you took out all 5 of your children, and then you wanted to mutilate their bodies, and then you dumped them in another state. Didn't not even give the mother a chance to give them a proper burial. You deserve the death penalty, period. That's how I feel about it. So I'm going to go and pull up his appeal from South Carolina. That is what we're going to do first. And then we're going to watch the oral arguments. So hold on for just a minute. Okay. I am still awaiting the official word from Alex Murdaugh if his case was overturned. They have not put down the opinion has not come out yet. So that's why I'm not talking about it yet. Hang on. Timmy, what's his name? Timmy Jones Jr. All right, here we go. Oh boy. Okay, get this to pull on up. So here's what we're going to do. I'm going to have to share my screen over here. How am I going to do this? Okay, now that looks a little silly. Why does it look like that? Okay, now put this back up over here because I'm going to share my screen. If I can get this to come up over here, that would be lovely. We're going to stop sharing that one. We're going to share our other screen so you can see what we're looking at for his appeal. There it is. Okay, good. Now, I might have to split the screen a little bit so I can move this over here so that I can read it because I'm not going to be able to read it over there. All right, so there's that. All right, here we go. Move this over just a little bit to move it over the right way. The state respondent versus Timothy Ray Jones Jr., appellant 2023. The Supreme Court of South Carolina. The state respondent versus Timothy Ray Jones Jr., appellate case number 2019-001008. And this was decided on July the 19th, 2023. Maybe we should watch the oral arguments first. Let's watch the oral arguments first. I think that would better serve us. Okay, so let's go get the oral arguments so that you can see them. All right. And I'm excited because not every state will let you show their oral arguments. Oral arguments for his appeal. Okay, here we go. All right. Let me get this pulled up. Well, now come on. Okay, it's going to take me just a minute to get this. Okay, appellate video. All right. Here we go. This is going to be, that's not the right one. Oh, I think it's on YouTube. Let me pull it up over here. We'll pull it up over here, his appeal, oral argument. Okay, hang on. I forgot that they had it on here. Okay. Let's get this pulled up over here. That's the boy. There's a lot of video on him because it was such a long case. You know, because when you had so many people, that the trial was so long, and it took all of that to basically, it is horrific. I don't know. It's just so much. I'm just so. It's sickening. It's absolutely sickening. The guy makes me sick. Okay, let me get these. I need to get these oral arguments filled up so we can actually take a look at them. It is something I enjoy watching. I know y'all enjoy watching it too. So, there we go. Let me put it over here. So I got to get the South Carolina appellates. Okay, appeals court. Okay, and that's right there. So there is the judicial branch. Now let's go get the archives. Okay. Video portal is right there. Now let's go get him. Okay. I think I have to put his name in here right here to get it to pull back up right. Let's see. Court of Appeals cases, archives are here. Okay, here we go. Now, by case number. Oh shit. Let me see if I can get his case number right here. Maybe I can just put by his last name, you think? I don't know. Let's see if I can get it to pull up this way. Oh, case name. Sorry. It's right here. Hello, Stilly. Let me. Jones Jr. Let's see. Come on now. Come on. Oh, I might have to go get his appeals number. Let me get this appeals number right here. It's on this right here. I got to get the number. It's right here. We get his appeals number to put in here so we can actually pull up the video. And then we can read the decision after we watch the video, which will be great. All right, here's the case number. Paste. Search. Okay. Come on, man. It's right there. I know it is, courts. All right, hang on. Just Court of Appeals. Let me see if I can pull it up from over here. Okay, Timmy Jones Jr. Oh my gosh, come on. Why isn't it showing me this? I was able to pull this up yesterday, so I don't understand why I can't pull it up today. This is craziness now. All right, we'll give it one more chance looking it up this way. Court of Appeals. Okay. Okay, this is going to throw me for a loop, isn't it? Okay, let's see. Courthouses. Right. Oh, wait a minute. I think I have to go to, okay, sorry. I think that's the wrong, I'm sorry. That was the wrong court. Sorry, guys. Yeah, it takes a minute sometimes. Okay, so South Carolina Criminal Court of Appeals. Do it this way. Sorry, guys. All right. Oral argument video. Tim Jones Jr. Now, come on, show it to me again now. Here we go. All right, enter. Okay, here it is. Here is the Timothy. Okay, that is that. That is the Timothy Jones defense closing argument. That's not what we want. We want the appellate portals. Okay. There's the appellate. Oh, there's the appellate portals. Now let's see if we can get this to pull up. There he goes. Okay, video, South Carolina. Okay, Court of Appeals roster and cases, live stream. Here's what we want. Okay. Now, let's go find it. All right. I got to go find it from over here. All right, hang on. What? Okay, wait a minute. I don't want to watch the live stream today. I want to watch the Court of Appeals from, here we go. Maybe I can just put it in right here. Okay, where is the, oh, right here. Sorry, go. Search. Okay, hang on just a second, guys. Let me get this to pull up again. Oh boy, this is different. Watch live, awareness. Nope, that's not what I want to do. Oh, it's trying to show me what's going on today. That's kind of silly. Video portal. Okay, here we go. You find your video here. Case name is going to be Jones. And it's 2019. Here we go. Paste. Search. Oh, come on. I don't understand why I can't pull it up. Okay. Oh, boy, this is really sad. I know it's there. I saw it. Okay. Well, we'll see if we can just find it over here again. Okay. Court of Appeals. Here we go. I mean, the cases like this, it's such a big case. It was huge. Okay, so South Carolina Court rejects his appeal. Okay, here we go. Let's see what we got here. All right, here we go. We're going to share our screen over here. If I can, where's my damn? Okay, I forgot where I was. I'm going to pull this up. All right, let me try to share the screen over here with this one. Okay, we're going to quit sharing it right there. Oh, wow, that why is that so big? Share the screen. Okay, here we go. Come on, share the screen. Oh, what is it doing? Stop. Okay, I don't know what's happening to it, but it is too big. And okay, put that right there. Oh my Lord, what happened to it? I can't. All right, here we go. Come on. All right, here. No. Oh, good. Thank God I was able to fix it. I was like, oh my God. I didn't want it to be completely messed up. Let's share our screen. All right, here we go. Well, I guess we're going to watch this right quick. And now this is going to be share. And this is going to be from, again, News 19 WLTX. So full credit to them. And we're going to listen to this right now. Here we go. Let me make it bigger.
Will sound familiar to you.
Here
The
we
South
go.
Carolina Supreme
Thank you.
Court has rejected the most recent appeal for Timothy Jones
showing on this
Jr.
side.
Now, this is to appeal
That's
the
crazy.
case from 2014 where he murdered his 5 children. The court did agree that the judge erred in 2 different decisions. However, it felt that those were harmless errors and not the grounds to overturn his convictions for those murders nor the death sentence.
All right. So we're going to take that down. All right. Okay, now let me see if I can go down here and find this other one. It was huge. I'm glad that they rejected it. You know, that's March 1st. Hang on. That's DC. Hang on a minute. We'll find it down here. Okay, there's denies that. I want to find the actual appeal. Okay, who is this one? This one is the state of Texas. We need South Carolina. That's the penalty phase. Just a second, South Carolina. It's a quarter. Okay, I just want to see the appeal. We might not be able to watch the appeal because, like, I can't. Here's request to overturn me. Oh, this is it. Is this it? Oh, no, this is the news
The South
story.
Carolina Supreme Court considering a South Carolina father's appeal to have his death sentence overturned.
Timothy Jones killed his 5 children in their
Thank
home
you.
in Lexington back in 2014. Now, pictures of the children's bodies were taken during
It's
the
just
investigation,
horrible.
and prosecutors offered to show the pictures to the jury during Jones's trial. Well, today, the court heard his request to overturn his murder convictions and death penalty, saying those pictures unfairly upset the jury to sentence him to death. Of course, we'll keep you updated and let you know what the court decides.
Yeah. All right. Well, here's what we're going to do. We're going to go ahead and start reading what the court decided right now because they cannot seem to find the oral argument today. And I don't want to waste a lot of time because I know people have things to do and places to go. So we're not going to make this too long, but it is a terrible case. And here we go. This is what they affirmed. Okay, this needs to go away. Why is this sitting there? No, go away. No, I don't want to see that. All right, here we go. It says, Chief Appellate Defender Robert Michael Duddick, Appellate Defender Susan Barber Hackett, and Appellate Defender David Alexander, Appellate Defendant Laura May Cotty, and Appellate Defendant Taylor Davis Gillum, all of Columbia for the appellant. Attorney General Alan McCrory Wilson, Deputy Attorney General Donald J. Zelinska, Senior Assistant Deputy Attorney General Melody Jane Brown, and Assistant Attorney General Tommy Evans Jr., all of Columbia, and Solicitor Samuel R. Hubbard III of Lexington for respondent. So Justice James, Appellant Timothy Ray Jones Jr. admitted to killing his 5 young children and was indicted for 5 counts of murder. He was convicted by a jury and sentenced to death. In this direct appeal, Jones raises 8 issues centering on 3 points: juror qualification, requested voir dire, and related jury instructions. Evidentiary rulings made during guilt sentencing. Let me pull this back up some. Here we go. There's some weird thing that's sitting right in the middle of it. I don't get it, but anyway. Okay, there's this little box sitting right here in the middle of this that I can't seem to make it go away. Anyway, so the other points were, and evidentiary rulings made during the guilt sentencing phases. We affirm that the juror qualifications, the voir dire, and jury instruction rulings means they affirmed those. We hold the trial court erred in certain evidentiary rulings. However, we hold the errors were harmless and affirmed Jones's conviction and sentence. So it was not overturned. Here's the background in this case. The background summarizes the details surrounding the murders and Jones's actions in the succeeding days. Jones and his wife were divorced and had 5 children. They had an informal joint custody agreement, with Jones being the children's primary caretaker. Throughout the day of August the 28th, 2014, Jones smoked spice, a form of synthetic Mary Jane, and at work to cope with the stress of impeding projects. Jones left work late in the afternoon and went to his home in Lexington County. He smoked more spice before leaving home to pick up his children. Abigail, age 1, and Gabriel, age 2, were staying at a neighbor's house, and Nathan, age 6, Elias, age 7, and Mariah, age 8, were participating in after-school programs. Jones retrieved the children and purchased takeout from a local restaurant. It doesn't sound like he planned on doing it, does it? No, it kind of doesn't, but we'll keep going here. All right. Let me get this picked back up. Okay. After Jones and the children returned home with their supper, Jones discovered an electrical outlet in the house was not working. Now, this is all started over an electrical outlet. Think about that. That is horrific, all right, and ridiculous. He accused Nathan of tampering with the outlet because Nathan had an unusual interest in electricity. To get Nathan to admit he has played with the outlet, Jones forced Nathan to do 100 push-ups. Now remember, Nathan is only 6 years old. 6 years old. And he's expecting this child to do 100 push-ups, 100 sit-ups and 200 squats, all in sets of 10. This is a 6-year-old baby. Nathan never admitted to playing with the outlet, but Jones later heard Nathan telling his mother over the phone, "It was an accident, Mommy." Enraged, Jones sent Nathan to bed. Later that night, Jones went to check on Nathan. He shook Nathan by the shoulders and demanded to know what happened to the outlet. Nathan collapsed on the floor. Jones told Elias and Mariah he thought Nathan was dead, and Mariah confirmed Nathan was not breathing. Now, this is the story here, because the cops proved something else. Here we go. Let me move this back up over here. Golly, come on, thing. Stop doing that. All right, here we go. It went too far down. Okay. So, come on, go back up. Why is this thing do? Oh, boy, it's so hard to deal with sometimes. Jones searched on the internet for a violent male-on-male rape scene from the movie American History X and began to fear things he would endure in prison, like a baby killer. At approximately 2 a.m., Jones took Mariah with him to purchase 10 packs of cigarettes at a nearby convenience store. Jones claimed that on the way home, he heard voices in his head telling him to kill his other 4 children because they would be better off in heaven than with their parents. Right? This is terrible. When Jones and Mariah returned home, Mariah went to bed. Jones smoked 2 bowls of spice, walked to the living room where Elias and Mariah were sleeping. Jones wrapped his hands around Elias's neck and strangled him to death while Elias begged, "Dad, take me with you." Jones then turned around toward Mariah, who pleaded, "Daddy, I love you," and strangled her to death. Jones proceeded to strangle Abigail and Gabriel to death using a belt because his hands were too big to wrap around their tiny necks. This is what kind of monster we're talking about right here. Jones next tried to kill himself by smoking 7 or 8 more bowls of spice. Like that's going to kill you. Oh God. You know what he is. Never mind. I'm not going to say it. Am I going to get rid of that chat right there? Please. Oh, I got rid of it. Yay. Okay. So then he smoked 7 or 8 bowls of spice. He woke up the following day and became paranoid, thinking it was a matter of time before he was arrested. Jones decided he would go to Las Vegas. He wrapped up each of the 5 bodies in bed sheets and stacked them in the back seat of his Cadillac Escalade. For the next 8 days, Jones kept the bodies in his vehicle and drove back and forth through South Carolina, Georgia, Alabama, and Mississippi. At various points along the way, Jones purchased spice, trash bags, chemicals, goggles, a dust mask, and a jab saw. During the trip, he searched online for applicable extradition laws and local dump sites, landfills, and campgrounds. So here he is, thinking about how he's going to get rid of these bodies as if he's going to get away with this. It sounds crazy, but he is not crazy. He's just a cold-blooded murderer. Okay, so let's get back over here where it was. All right, now. On September the 6th, 8 days after the murders, Jones placed his children's bodies in trash bags and dumped them in a rural area near Pineapple, Alabama. Later that day, Jones was stopped at a safety checkpoint in Smith County, Mississippi. Officer Charles Johnson testified that as Jones approached the checkpoint, he smelled a strong odor of burnt marijuana and garbage from, coming out of the vehicle. Officer Johnson noticed Jones' eyes were red and glassy, and his speech was slurred. Officer Johnson asked Jones to pull to the side of the road, and Jones consented to search his vehicle, which revealed bleach stains on the floorboard, synthetic marijuana, drug paraphernalia, bleach, muriatic acid, charcoal fluid, and scribbled notes reading in parts like head to the campground, like telling him what to do. Head to the campground, melt the bodies, sand to dust or small pieces. And day 1, burn up the bodies. Day 2, sand down the bones. Day 3, the Mexican border. Oh my God. And then it goes, and dissolve and discard. And then Jones was arrested for driving under the influence, possession of controlled substances, and possession of drug paraphernalia. A dispatcher advised the officers of a hit on Jones's vehicle for 5 missing children. Jones confessed to the murders as soon as he was arrested. And on September 9th, 11 days after the murders, Jones led the law enforcement to his children's bodies. The bodies were still in the trash bags, and the children were unrecognizable due to severe decomposition and animal activity. Jones was extradited from Mississippi to South Carolina, where he was indicted for 5 counts of murder. The state sought the death penalty, claiming the following aggravating circumstances applied. Number 1, the murder of 2 or more persons by one act or pursuant to one scheme or course of conduct. Number 2, the murder of a child 11 years of age or under. Number 3, Jones entered into a plea of not guilty by reason of insanity. Well, Letitia Stouch was going to try that too. Remember that? Pursuant to the South Carolina Code, subsection 17-24-10, the jury rejected the insanity defense and returned 5 guilty verdicts and recommended the death sentence. The trial court adopted the jury's recommendations and sentenced Jones to death. Jones raises the following issues in his direct appeal. Did the trial court err in qualifying juror number 156? Did the trial court err in disqualifying jury number 338? Did the trial court err in denying Jones's request for voir dire and jury instructions detailing the consequences of not guilty by reason of insanity verdicts? Did the trial court err in denying Jones's motion to suppress evidence obtained as a result of the safety checkpoint? Number 5, did the trial court err in excluding Dr. Adrian Flores' expert testimony during the sentencing phase? Number 6, did the trial court err in limiting testimony pertaining to Jones's future dangerousness? Remember, we just watched in the Tanner, they talked about his future dangerousness, remorse, and social history during the sentencing phase. Number 7, did the trial court err in excluding Cynthia Turner's pre-recorded testimony during the sentencing phase? Did the trial court err admitting autopsy photographs of the victims during the sentencing phase? Here's the discussion on it now. Guilt phase. Number 1, qualifications of juror number 156. The determination of whether a prospective juror is qualified to serve on a capital jury is within the sole discretion of the trial judge and is not reversible on appeal unless wholly unsupported by the evidence. And it's State versus Evans, and there's the citing on that. When reviewing an alleged error in the qualifications of a juror, we conduct 3-step analysis, giving particular deference to the trial judge who sees and hears the juror. State versus Green, and there's the citing for that. First, we must find that the appellant exhausted all of his preemptory challenges. Second, we must determine that the disputed juror was erroneously qualified. And third, we must conclude the erroneous qualification deprived the appellant of a fair trial. We have repeatedly held that to determine whether a juror was erroneously qualified, the challenged juror's responses must be examined in light of the entire voir dire. A juror is erroneously qualified when his or her views on capital punishment would prevent or substantially impair the performance of his duties as a juror in accordance with the instructions and his oath. In other words, if you were against capital punishment, then you were not qualified as a juror because you can't read the instructions and follow. You can't follow the instructions, right? So then he goes, I'm just explaining why they would be disqualified. It's the ultimate consideration is the juror to be unbiased, impartial, and able to carry out the law as explained to him, State versus Sapp. Now, Jones exhausted all 10 of his peremptory challenges before juror number 156 was seated, thus satisfying steps 1 of our analysis. Step 2, whether the trial court erroneously qualified juror number 156 is the crux of Jones's challenge. Jones argues that juror 156 was erroneously qualified because, number 1, he was unwilling to consider social history as in the evidence that did not, okay, this is weird. He was unwilling to consider social history evidence that did not involve the facts or the circumstances surrounding the murders. And number 2, he could not consider voting for a life sentence on the basis of mercy. We disagree. So they disagreed with him. During the voir dire, the trial judge questioned whether juror 156 could consider the facts of Jones's case in an unbiased manner. Juror number 156 told the trial judge, I believe that all the evidence and the facts should be presented and taken into consideration when you are talking about somebody's life, especially what this case deals with. And he was talking about the death penalty. Moments later, the trial judge asked juror number 156 to identify himself as one of 3 types of capital jurors. Type number 1, jurors who believe the death penalty is appropriate when a defendant is convicted beyond a reasonable doubt of an aggravated murder. Type number 2 is jurors who believe life without parole is appropriate when the defendant is convicted beyond a reasonable doubt of an aggravated murder. And type 3, jurors who believe the death penalty or life without parole may be appropriate when the defendant is convicted beyond a reasonable doubt with aggravated murder. Which all sounded the same, doesn't it? It does. Juror number 156 replies, I find myself torn between. I see myself as type 3, but depending on the facts, I can quickly bring myself to type 1, depending on the facts and the evidence. Throughout his testimony, juror number 156 continually emphasized he could meaningfully consider the testimony and the evidence presented in light of the trial court's instructions and that the 4 verdict forms, all while being fair and impartial to both sides. When the trial judge questioned juror number 156 about the sentencing phase of the trial, juror number 156 said he understood the death penalty is not automatic and reiterated, I believe you have to take into consideration all evidence when you're talking about somebody's life. Juror number 156 continued, if the evidence calls for the death penalty, then I feel like as a human being, we have to determine whether to take that the person's choice to live or not. Finally, juror number 156 told the trial judge he could recommend either the death penalty or life without parole, depending on the facts presented, which is exactly what you would expect. During the state's examination, the solicitor asked juror number 156, so if you were to sit on this jury and you reach with your colleagues, your co-jurors, the decision he is guilty of murder, would you already have your mind made up coming into the second phase, or would you want to hear additional stuff of the good and the bad, the aggravating and the mitigating before you made your decision? Again, juror 156 reiterated, every ounce of information, evidence, facts, mitigation, everything needs to be taken in consideration before the final decision. If the evidence at the end of all of this, mitigation, aggravation, and all of that, it constitutes for the death penalty, then what is right and what is wrong is wrong. And I agree with him right there. Okay. At the conclusion of the state's examination, juror number 156 told the solicitor he had not made up his mind. Instead, he wanted to hear all the facts before making a final decision. During the defense counsel's examination, juror 156 explained he wanted to hear everything, the defendant's good, bad, past, and future, before coming to a sentencing decision. Juror 156 stated he understood and respected that jurors have the right to decline imposing the death penalty solely based on mercy, but he also expressed his belief that based on the facts presented, jurors should be able to explain why they made a particular sentencing decision. Defense counsel then asked, somebody might say, I can't explain it to you. This is what I feel is right. Can you respect a juror's right to say, I don't have a reason. This is my moral judgment. This is what is right for me. I've got to do it. Juror number 156 replied, it might sound harsh when I say this, but if they say that after being presented the facts, I don't believe they should be here, soon after the juror 156 stated, boy, this is hard. Look, what they are drilling this juror. He's just a potential juror. They're just drilling him. Wow. During the state's final examination, okay, wait a minute. Yeah, that's where I was. The solicitor questioned whether 156 could consider mitigation factors before recommending a sentence, and juror 156 responded. Again, I am thinking it needs to be within a reasonable time. But when we are here for the murders of these kids, it needs to be involved around this, the mitigating factors that have something to do with the case. But I mean, when you are talking about somebody's life, there is nothing wrong to me with getting all of the facts and all of the evidence. The solicitor then asked whether juror number 156 could consider mitigation evidence. Man, they just keep drilling him. Presented by the defense that went way back, and you're again emphasizing the facts stated. Yes, I don't see why it could do any wrong. But like I said, for me personally, what happened 20 years ago when you were in elementary school doesn't have anything to do with your decision now. And I agree with him on that too. But like I said, I will be willing to, when you're talking about somebody's life, like I said, if the defense wants to give up the facts, the prosecutor wants to give their facts, I'm willing to listen to both before making an ultimate decision. Finally, the solicitor asked whether the ultimate sentence for juror number 156 recommended would depend on facts or just feelings, and juror 156 answered facts. It should always be facts, never your feelings. You have to set that aside when you're considering a death penalty case. Or any case, really, you've got to follow the law. After juror 156 left the courtroom, Jones moved to excuse him as being substantially impaired in his ability to follow the law. Essentially, Jones argued that juror 156, number one, mitigation impaired in that he could only consider mitigation evidence within a recent timetable, and number two, unable to respect the rights of other jurors to decline imposing the death penalty based on mercy alone. The state responded that juror number 156 was a facts guy who was willing to listen to all mitigation evidence, even though he had a difficult time understanding how distant evidence could relate to present time. Based on the totality of the juror 156's testimony, including him stating repeatedly he wanted to hear all the facts before making a huge decision of taking somebody's life, the trial court qualified juror 156. Jones objected under the 6th and 14th Amendment, again claiming juror 156 was mitigation impaired and unable to consider mercy. We agree with the trial court's qualifications, and I do too. Juror 156 repeatedly stressed throughout the voir dire the importance of facts. He never indicated he would automatically impose a death penalty, and instead stated his sentencing recommendation would be wholly determined by the evidence set forth at the trial. When asked questions regarding preconceived notions about the death penalty, juror 156 reiterated, I go back to the evidence. Although juror 156 initially expressed doubt about how mitigating evidence from a defendant's childhood could affect the defendant's present decision-making, he completed his responses with, but like I said, I'm willing to listen to both sides before making the ultimate decision. Juror 156 never rejected the possibility of a mercy sentence. Rather, jury 156 stated his belief that even if a mercy sentence was imposed, a juror should be able to articulate why he or she chose mercy. Jones improperly isolates juror 156's statement. I don't see how you can be here and be fair to both parties if someone says, well, I feel merciful. That statement must be considered in light of juror 156's entire voir dire, including his preceding statement. I think after you are presented the evidence and the facts, you have a reason. You have a reason of the way you feel and the decision you make. Together, these responses reflect jurors 156's desire for jurors to specify the reason why their decisions. But they do not insinuate that juror 156 was unable to impose a life sentence based on mercy alone. For these reasons, we affirm the trial court's qualifications of juror number 156. And now we're going to go to juror number 138. Juror 338. Now they're going to him. On review, the trial court's disqualification of a prospective juror will not be disturbed. Where there is reasonable basis from which the trial court could have concluded that this juror would not have been able to faithfully discharge his responsibilities as a juror under the law. Green, and there's the citing for it. We jurors under the law must be particularly deferential to the trial judge who sees and hears jurors, keeping in mind that in certain situations, the trial judge may disqualify a juror based on a definite impression that he or she would be unable to return a verdict according to the law. When defense counsel examined juror 338, he questioned whether juror 338 could fairly consider an NGRI. Particularly, the defense counsel inquired, if in your mind you thought, and this is an expert witness, presented enough information to support that verdict, is that verdict that you could really consider, or would you still have some hesitation because it would kind of be letting someone off still? Juror 338 responded, it would depend on the information provided and the plan of action after that. So obviously, you claimed insanity. You wouldn't just become part of the society again. Okay, what would be that plan? So you have been declared insane, and then what? Now what? Essentially, around this time, the state objected, and juror 338 was briefly excused from the courtroom, and should have been. That was proper. After discussing this line of questioning, the trial judge ruled the defense counsel could ask juror 338, not knowing what would happen, would that cause you to perhaps not consider an NGRI verdict? Juror 338 answered, I would need to know what happened to consider the verdict. Soon after, the state objected again. The trial judge clarified, the end result plan is not allowed to be given in a trial. Okay, it is not. So he's asking you, if there were a case, then if that were the case, would that affect your ability to consider an NGRI verdict? And the following exchange took place. Now, they're just almost arguing with these jurors. It's ridiculous. Juror 338 says, can I ask a question? And the court says, you may. Juror 338 says, so in the case of the death penalty, death is the result. The court then says, yes, that is the result. Juror 338, and if you know the life sentence without parole, you know that also is a result. And the court says, correct. Juror 338, but in case of not guilty by insanity, you don't know the result. And the court says, don't know the result? And juror goes, I don't understand. The court, this is the court telling this to the juror now. This is just the court rules. So the result of that you would always be in the dark without regard to the results of not guilty by reason of insanity verdict. In other words, if you give him this, you're not going to know how long he's put in a hospital, etc. So they won't know the end result. Knowing you would always be in the dark about that, not knowing what would happen, would that cause you to maybe not consider that verdict as a true verdict? Would you vote for it not knowing what would happen? Juror 338 says, I have no words, honestly, because without knowing what the result is, how can you choose that option? And then the court says, so it sounds like you do have some reservations about choosing that option, not knowing the result. Number 338 juror says, it's just not knowing the result. The result of the other options, but you don't know in the result of that option. The court says, okay, she has answered, and that's sufficiently, and let's move on. Wow, I can't imagine drilling these jurors like this. At the conclusion of the voir dire, the state argued juror 338 was unqualified because she had unanswered questions about the consequences of the NGRI verdict. In response, the defense counsel contended that although juror 338 expressed concern and confusion about not knowing the consequences of an NGRI verdict, she did not express a complete inability to consider that verdict. Ultimately, the trial judge excused juror number 338, noting, since I can't answer your questions, and that is a big concern of yours, being able to go forward and make that decision, I'm going to excuse you from jury service. Defense counsel objected, asserting that just having concerns doesn't disqualify somebody, and we agree with the trial court's rulings. I agree with it also, because it tells me that she's thinking with feelings, not with the law. Okay. Jones argues that juror 338 should have been qualified because her responses indicated that she could meaningfully consider NGRI verdicts. In Jones's view, juror 338 was simply concerned about not knowing the outcome of such a verdict and confused as to why jurors were told the outcome of two potential verdicts during the penalty phase, but not the outcome of an NGRI verdict. Jones alleges that juror 338 never indicated she would be unwilling to return a verdict of not guilty by reason of insanity. Much like the juror's response in SAP 366, South Carolina, there's the citing, juror 338 responses reflected her complete inability to render a verdict according to the law. See, to me, it sounds like she was using feelings, not the law. When asked if she could consider an NGR verdict without knowing its consequences, juror 338 unequivocally stated, I would need to know what happened to consider that verdict. Thereafter, she expressed confusion as to why the jury was informed of the consequences of the guilty verdict, the life without parole, or death, but not informed as the consequences of the NGRI. The trial judge explained he was bound by court rules, which do not permit such an instruction, and then asked juror 338 whether she could consider NGRI verdicts, knowing she would be in the dark as to its consequences, and juror 338 again stated she could not. So she's disqualified. She should have been disqualified. As we discussed immediately below, the state and federal laws do not require a jury to be informed of the consequences of an NGRI verdict during the guilt phase of a capital trial. To discharge her responsibilities as a juror, juror 338 must have been able to fully consider each of the verdicts before her and decide upon a verdict in accordance with the law, because juror 338 ambiguously stated that she could not consider an NGRI verdict unless she was informed of its consequences, and because the trial court is forbidden from informing the jury of those consequences, we affirm with a disqualification of number 338. Here we go. Denial of Jones's request for voir dire and jury instructions detailing the consequences of the NGR verdict. Again, he's already said, under the law, we cannot do that. It's the rules. We can't change the rules here. The trial court denied Jones's request for voir dire and jury instructions detailing the consequences of the NGRI verdict. We affirm the trial court's ruling on this issue. They had no other choice but to affirm that. In State v. Poindexter, the defendant was charged with murder. The potential verdicts in the case were guilty, not guilty, NGRI, and guilty but mentally ill. The jury found the defendant to be mentally ill. The defendant appealed, arguing that the trial court erred in refusing to inform the jury of the consequences of each of the verdicts during the voir dire, the opening statements, the closing arguments, or special instructions. We affirm the trial court's ruling, noting this. Voir dire is not to be used as a means of pre-educating or indoctrinating a jury as a means of impaneling a jury with a particular predisposition. In our view, the discovery and elimination of biased and prejudiced jurors during voir dire does not require that they first be informed of the consequences of each of the potential verdicts. Okay, now, ID at 492, anyway, the citation was admitted. With respect to jury instructions, after jury is seated and sworn, the trial judge shall instruct the jury on the current and correct law, State versus Taylor. To warrant the reversal, a trial judge's charge must be both erroneous and prejudicial. On several occasions, this court has considered whether South Carolina law requires jurors to be instructed on the consequences of an NGRI verdict. We have held that it is non-capital trials, absent agreements by the parties. A consequences instruction is improper unless it would be a curative under the facts of a particular trial, or it's required to clarify a misstatement of law and would not prejudice either party. Okay. The justification for this rule is in non-capital trials. The jury has no sentencing responsibility, and sentencing is irrelevant to the determination of guilt. Okay, let's get past that. In a capital trial, which is uniquely bifurcated, which means they separate it between guilt phase and then sentencing phase, just like they do Texas, just like they did Tanner Horner, okay? Except Tanner Horner actually pled guilty first. The rule applies for different reasons. Number one, the NGRI is a verdict during the guilt phase, not the sentencing phase. And number two, if an NGRI verdict is rendered, the jury has no sentencing responsibilities. And then, it says see State versus Bell. Although we acknowledge there is a trend toward requiring consequences in the instructions, we decline to join the trend. Jones alternatively argues that the trial court's denial of his request violated due process clauses and the Eighth Amendment of the United States of the Constitution, and we disagree. Okay, here's where they're going to go with that. Now, hang on a second. Somebody's beeping me. Okay. Okay, I'm on now. She's just now realizing, hang on, I'm on now. Here we go. All right. Well, wait a minute. Okay, so let's get back. So we're going to let Sprinkle come on up. I guess she didn't realize it said 2 o'clock. I guess that's my fault because I didn't tell her 2 o'clock. I just sent her the link to get on. So sorry. Anyway, we'll get back over to where we were. Okay. Okay. Come on. We'll just take a break for just a minute while we wait on her to come on. It's okay. It's okay. Yeah. This stuff is so interesting because, you just never know. It's okay. Let me turn this off. You just never know, really, when you start looking at their appeals and their trials and the act that got them there. You just never know what you're going to think about it until you've seen it all, because you're almost like a jury. You're trying to think to yourself, do you agree, disagree? What do you think? Do you think they made a mistake, etc.? I just think they're very interesting myself. Well, while we wait on her, just a second, we'll just sit here a minute while I wait on her to come on. She goes, oh shit. I'm like, oh, whatever. We make mistakes. Okay. I guess, I just forgot to tell her, oh, remember to jump on it too. I just kind of threw the link out to her and then just got busy over here. So it's all right. Well, we'll just wait a second. Oh boy, it's a lot of reading, but I think it helps us to learn all of these things too, because when we hear about these other trials that we love to watch, and we hear them talk about they say certain statements, or they talk about certain verdicts, or talk about certain rules, then we already know what it is because we've already talked about it and read it or heard it in some other trial that we've looked at. So I think it's good to learn from these trials. Come on, I guess. Well, I guess I'll just keep reading because she's not here yet. Okay, so where were we here? All right. In support of his due process argument, Jones cites Simmons versus South Carolina and Kelly versus South Carolina, all of which deal with an instruction on parole ineligibility, not an instruction on the consequences of an NGRI verdict. Jones emphasizes that, like Simmons, Schaefer, and Kelly, these cases involve a capital trial. However, those cases are distinguishable because they deal with a jury's instruction during the sentencing phase, not the guilt phase. Okay. As explained above, capital trials are uniquely bifurcated, and says see South Carolina. Because a capital jury has sentencing responsibilities in the sentencing phase, it makes sense that certain situations, the due process clause, requires the trial court to instruct the jury on the effects of potential sentences. In the guilt phase, however, a capital jury has no sentencing responsibility. Their jury's sole function is determining the guilt or innocence of the defendant. The mere possibility of particular verdicts cannot support the consequences and the instructions. There is no guarantee the jury will proceed to sentencing in the first instance. Therefore, we reject Jones's due argument. Okay? What did she say? Hang on a second. What did she say to me? Oh gosh. Okay. Let me pull up this link. Okay. Well, let me just put it over here for you. Hang on a second. I'll just put it in the chat. Here we go. I can share the screen. I thought she just said it didn't work. There you are. It's working. All right.
It is. I had to do it like 3 times. Sorry, I was just dozing off, and I looked up and I was like, oh my God.
It's all right.
Oh no.
All right. I thought maybe you just got busy. It's fine. Because I know, we know on your days off you do have things to do, so it's okay.
Yeah.
It's on.
No,
I
just had that bad insomnia in the last couple of nights. Night before last, I didn't sleep at all. So
Oh,
I
I
was
hate that.
exhausted last night, and then I'm just like catching up, I think, from the week. Just
Yeah. Well, you
exhausted,
need
but
sleep,
I'm
and
sorry.
it's okay.
Yeah.
Okay. You're excused. I wish I had the stapler like Justin does. So I could say excused.
Yeah,
Anyway.
little gavel. Clang.
So, here we go. So we're talking about sentencing in the first instance. Therefore, we reject Jones's due process argument. Jones next argues that the heightened reliability requirement of the Eighth Amendment requires capital juries to be informed of the consequences of the NGRI verdict, particularly where the defendant is mentally ill or less culpable due to his mental state. And it goes see Woodworth versus North Carolina, explaining the heightened need for reliability in capital trials as compared to the non-capital trials. To support his argument, Jones cites 3 federal cases prohibiting the execution of a mentally ill defendant. He goes see Ford versus Wainwright, Atkins versus Virginia, and Hall versus Florida. However, Jones overlooks the fact that in these cases, the jury expressly found he was neither mentally ill nor insane. For this reason, we reject his Eighth Amendment argument. So what they're saying is, had the jury agreed that he was mentally ill or insane, then that would apply. But they did not agree that he was mentally ill or insane, so those don't apply. Number 1, denial of Jones's motion to suppress. Then he wanted the evidence suppressed. Of course he did. Quite by chance, on the same day, Jones disposed of the children's bodies. He was apprehended at a safety checkpoint in Smith County, Mississippi. Deputy Charles Johnson, one of the 2 officers conducting the checkpoint, testified that because things were quiet on the night of September 6, 2014, he and Deputy Robert Thompson asked Smith County under Sheriff Marty Patterson for permission to conduct a safety checkpoint. Sheriff Charlie Crumpton testified safety checkpoints were intended to check for driver's license, seatbelt violations, proper child restraints, and proof of insurance. Sheriff Crumpton, well, that sounds to me like a setup, doesn't it? Sheriff Crumpton estimated approximately 10% of the drivers are ticketed or arrested for safety point checklists. Hey, Cinderella, so good to see you, girl. How you doing today? You doing okay? We're just
Hey,
reading about Timothy Jones Jr. He took all 5 of his children's lives, and when he could not get his hands around their neck because they were too small, the children's necks were too small, he just went and got a belt and finished it like that. That's what kind of person we're talking about. He's an absolute monster. So, something to see you. We'll just keep going here. And we're going to talk about him in just a minute. So, yeah, good. We're good. I'm glad you're doing good, Cinderella. That's good. So they're doing this checkpoint, and so they stop him. He also testified the department's verbal policy required that checkpoints be approved by a superior and conducted as a safe location by 2 or more officers who wear reflective vests and stop all the vehicles, not just some, but all of them. Deputy Johnson testified that he and Deputy Thompson followed the department policy. Deputy Johnson further testified he was normally equipped with a portable device to conduct breathalyzers on suspects of drunk driving. Jones moved to suppress all evidence stemming from the Smith County checkpoint, arguing that the checkpoint violated the Fourth Amendment because its primary purpose was for general crime prevention. The trial court denied Jones's motion, and he contends that the denial was improper. We disagree. So they don't agree with him on that, so that gets struck as well. The appellate review of a motion to suppress based on the Fourth Amendment involves 2-step analysis. The dual inquiry means that we review the trial court's factual findings for any evidentiary support, but the ultimate legal conclusion is a question of law subject to the de novo review, State versus Frazier. The United States Supreme Court has considered the constitutionality of checkpoints on several occasions. The Supreme Court has unequivocally held checkpoints constitutional in the Fourth Amendment and to the seizures, even though their purpose is limited and the time of the detention is brief, and this is United States versus Martinez. In Delaware versus Prowse, the Supreme Court considered the constitutionality of a random spot check designed to verify driver's license and vehicle registration. The issue is in Prowse arose when an officer on routine patrol decided to randomly stop a vehicle despite observing no traffic or equipment violations. In other words, because it was not a pre-approved use of their time, he just decided to do it on his own, that's why it was not okay for him to do. Anyway, the officer was not acting under the law enforcement guidelines and procedures pertaining to spot checks. the Supreme Court noted that there was no empirical data suggesting that spot checks produced anything more than marginal contributions to highway safety. Balancing the state's interest in the discretionary spot checks and the resulting intrusions of the privacy and security of the persons detained, the Supreme Court held that in incremental contributions to highway safety, it ensured by random spot checks is insufficient for a jury to justify a warrantless seizure under the Fourth Amendment. The Supreme Court clarified, however, that its holding did not prohibit the states from developing methods of spot checks that involves less intrusions, and that they do not involve the unconstrained exercise of discretion. This is low. Ugh. Critically, the Supreme Court suggested questioning all oncoming traffic at a roadblock type stop is one possible alternative. Well, they did stop everybody. They stopped all of them. So they weren't just picking on him, they stopped all of them. In Michigan Department of State versus Police, the Supreme Court considered the constitutionality of a highway sobriety checkpoint. The law enforcement policy in SITS requires all vehicles to be stopped at a sobriety checkpoint. If an officer suspects intoxication, he was required to direct the driver to pull over and produce a driver's license and vehicle registration. This data showed that during these challenge checkpoints, 2 out of 126 drivers were arrested for drunk driving. Only 2? That's pretty good. The Supreme Court distinguished that Prowse, noting that unlike Prowse, this case involves neither a complete absence of empirical data nor a challenge to random highway stops. Balancing the state's interest in preventing drunken driving, the extent to which the system can reasonably be said to advance to the interest, and the degree of intrusion upon individual motorists who are briefly stopped. In the SITS court held mandatory sobriety checkpoints survived the Fourth Amendment scrutiny. Okay, they're allowed. In the city of Indianapolis versus Edmond, the Supreme Court addressed the constitutionality of a highway checkpoint program whose primary purpose was to discover an interdiction of illegal narcotics. So they weren't even looking for drinking, they were looking for narcotics. The Supreme Court observed the stops in SITS and Prowse were concerned with highway safety, which is a significant Fourth Amendment interest. However, because the primary purpose of the Edmond program was not to ensure highway safety, but instead to uncover evidence of ordinary criminal wrongdoings. The Supreme Court held that the program violated the Fourth Amendment, and it does violate it. I agree with that too. Importantly, the Supreme Court repeated the suggestions made in Prowse that similar types of roadblocks with the purpose of verifying a driver's license and vehicle registrations would be permissible. I think it is too, because it is a public safety. That is their job, public safety. Here, the checkpoint was precisely the type of checkpoint suggested by the Supreme Court in Prowse and Edmond. The state presented evidence sufficient to prove that the primary purpose of the Smith County checkpoint was highway safety, not general crime prevention. 4 officers testified that the checkpoint was intended to check for driver's license, vehicle registrations, and proof of insurance. At no point did any witness suggest a contrary purpose. As in SITS, the Smith County Sheriff's Department had a policy requiring that all vehicles passing through that checkpoint be stopped in a safe, structured manner. Officers did not have unbridled discretion as it was in the case of Prowse. Instead, stops were brief, minimally intrusive. For these reasons, we hold the trial court did not err in denying Jones's motion to suppress. Had they suppressed that evidence, then they would not have been allowed to bring in the fact that the car smelled of bleach and basically death and the smell of spice. The officer says when he's testifying what he smelled. So imagine them not to be able to use that. They would have only had his words. And had they not been able to prove there was death in the car, then he might not have been admitted to it. He might have just kept on lying. Sentencing phase goes next. Exclusion of Dr. Adriana Flores' expert testimony. Now, let's talk about expert testimony. Because we've seen that in expert testimony, some of them are absolutely pay to play. In other words, if they need this person to look mentally insane, like Dr. Lewis tried to do, then she's going to write her report that way. But if they need the person to seem like they're normal, there's nothing wrong with them, then they're going to write the report that way. We know that some experts absolutely do that. We know they do. Okay. We've seen it before. The South Carolina Code provides jurors must consider several mitigating circumstances in a capital trial, including whether the murder was committed while the defendant was under the influence of mental or emotional disturbance, whether the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirement of law was substantially impaired, and the age or mentality of the defendant at the time of the crime. Okay. Additionally, the Eighth Amendment, which applies to the states through the 14th Amendments, requires that the jury in a capital case be able to consider and give effort to all relevant mitigating evidence offered by the defendant. And it's Boyd versus California and Lockett versus Ohio. This is particularly due to the qualitative differeces between ordinary criminal trials and capital trials, where there is corresponding differences in the need for reliability. Okay. Now this is kind of going back to the other day, just like Tanner. They were trying to blame it on autism. They were trying to blame it on this, trying to blame it on that, just like Letitia Stouch tried to use NGRI herself, but didn't work for her either. I'm pretty sure on her next trial, they're going to try it again. But I bet you they're not going to get Dr. Lewis next time because they realized that she just might as well have just been for the prosecutor. That was ridiculous, horrible, and she did them no good at all. She looked like a fool up there, actually. That's just my opinion. Generally, the admission of expert testimony is matter within the sound discretion of the trial court. State versus Wally. It will not reverse the trial court's exclusion of expert testimony unless the exclusion resulted from a prejudicial abuse of discretion. State versus Cope. An abuse of discretion occurs when the conclusion of the trial court either lacks evidentiary support or controlled by an error of law. State versus Croma. And quoting State versus Douglas. During the guilt phase of the trial, Jones presented testimony from several experts in an attempt to establish his NGRI defense. Their testimony is summarized below. In a reply, the state called the neuropsychologist, she's a neuropsychologist, Dr. Kimberly Krause. Because the testimony from Jones's insanity witnesses and Dr. Krause was also relevant for the foregoing statutory mitigation circumstances, it was incorporated into a sentencing phase. So, Dr. Krause testifies that she was asked by Dr. Richard Frierson, the court-appointed evaluator, to evaluate Jones. Dr. Krause interviewed Jones on February the 19th, 2019, approximately 2 months before his trial. Dr. Krause testified about several tests that she administered during her evaluation and explained how she scored the raw data. The tests included the MFAST, the SIMS, the SIRS, the MMPI, and the PIA-6. Now, we've heard about this MMPI before because I believe that Dr. Lewis talked about that for Letitia Stouch. We will need to go check that. Hey, Sprinkle, can you check and see if Dr. Lewis talked about the MMPI for at least Letitia Stouch? I think you can just look it up on yeah. Dr. Cruz testified. Okay, look for that while I do this. Dr. Krause testified her scoring of the raw data led to her to conclude that Jones was malingering symptoms of mental illness, just like our friend Letitia. She testified that malingering is voluntary, conscious, and self-directed behavior aimed at exaggerating symptoms or creating symptoms that did not exist. Yeah, right. As noted, Dr. Krause's testimony was incorporated into the sentencing phase. During that phase, Jones provided the state with an affidavit from the forensic psychologist, Dr. Adrian Flores. Dr. Flores was new to the case and was prepared to testify regarding errors and incorrect conclusions on the part of Dr. Krause. It's specifically with regard to Dr. Krause's scoring of the raw data. That led to conclude Jones was malingering. In her affidavit, Dr. Flores stated she was obligated under the American Psychology Association's ethical principles to confront Dr. Krause about her concerns. The solicitor, they're fighting here. The two, they're fighting. They're going to fight about it now. That's oh God. It's almost funny, but this is not funny at all. This case is very, very sad. The solicitor lodged 3 basic objections to Dr. Flores' testimony. First, he argues that Dr. Flores' affidavit and purported testimony were an attack on Dr. Krause. The solicitor argued that allowing Dr. Flores to testify would permanently stain Dr. Krause's personal and professional integrity and intimidate Dr. Krause to the point that she would be afraid to testify in response to Dr. Flores' allegations. Well, because she's talking about taking her before the board, she could lose her license. And, that over this case, that's not fair. Second, the solicitor argued that Dr. Flores would improperly pit her testimony against that of Dr. Krause. Third, the solicitor argued that the state would suffer unfair prejudice if Dr. Flores were allowed to testify without any notice to the state. The trial judge noted that trial had been underway for 6 weeks. 6 weeks! I'm telling you, this is a long trial. Dr. Flores was not on the witness list. It was going to be a last-minute surprise. Is that what we're seeing? And numerous expert witnesses had already testified for both parties. Defense counsel informed the trial judge that he discovered Dr. Flores' concerns the preceding weekend when defense witness Dr. Julie Dorney asked Dr. Flores to review Dr. Krause's testing methodology and conclusions. The defense counsel stated that as soon as he became aware of Dr. Flores' interest in testifying, he informed the state. Oh boy. The trial judge considered these arguments and ruled, I've got to draw the line somewhere. We're too far in the game to call new players. I presume you'll have to proffer her, but I don't think she should be allowed to testify. The record is not clear on this point, but apparently the defense had Dr. Krause's report and raw data in advance of trial. Okay, in advance of the trial, they had this. So no, he didn't just discover it. He had it before the trial started. The trial had been on for 6 weeks already. A little bit of lying going on there. Okay. Yet did not secure its own expert to review them. During her proffer, Dr. Flores testified she was concerned that Dr. Krause had admitted the validity section from one of these tests that she conducted, and in turn, Dr. Flores had the feeling that something was being hidden from Dr. Krause's report. The trial judge noted that what he termed improper pitting of witnesses and warned the defense counsel, just be careful not to pit these witnesses. If Dr. Flores took the raw data and scored it herself, then that's rescoring of the data. But if she's going to testify to the mistakes Dr. Krause made, that's pitting witnesses. So characterize your questions properly. Dr. Flores explained in detail several tests that Dr. Krause performed on Jones, and Dr. Flores explained the MFAST and the SIMS, the SIMS, were screening tests for malingering. And if the scores on those tests are above certain levels, the SIRS should be admitted. Dr. Flores testified she reviewed the raw data and determined that Jones's scores on the MFAST and the SIMS were below this cutoff level. So, below the cutoff schedule for malingering. Therefore, Dr. Flores' opinions that Dr. Krause should not have administered the SIRS, and Dr. Flores testifies as to her own scoring of the raw data and concluded, just looking at this data, I don't think there was enough information there to say that Jones was malingering. Of course not. In its brief, the state argues that the trial court properly excluded Dr. Flores' testimony. The state repeats its grounds for the exclusion as witness intimidation, improper pitting of witnesses, and this is Rule 403, SCRE. Okay, so the probative value of Dr. Flores' testimony was substantially outweighed by the danger of unfair prejudice to the state. The state also presents an additional argument that Dr. Flores' testimony would have amounted to a needless presentation of cumulative evidence under Rule 403. First, we reject the state's argument that Dr. Krause would have been so intimidated by Dr. Flores' accusations that she would have been afraid to testify and reply. As the state notes in its brief, at the time of the trial, Dr. Krause had served as chief neuropsychologist at Prisma Health for 11 years and had been qualified as an expert in the field of neuropsychology over 75 times. There is no evidence that Dr. Krause would have been afraid to return to the courtroom and testify and reply. Even if she had been, we question how this would be germane to the admissibility of Dr. Flores' testimony. Boy. Second, as the trial court concluded, and the proper transcript bears, Dr. Flores' testimony could have been tailored to avoid any purported improper pitting of the witnesses. The trial court had a firm grasp on the issue and could have resolved all the related objections. We therefore reject the state's arguments on this ground. Citing Rule 403, the state claims that Dr. Flores' testimony would have been needlessly cumulative in light of the testimony of the 8 defense experts. It had already been 8 defense experts. We're going to get number 9? Wow. Rule 403 proves in part that the relevant evidence may be excluded if it is probative value, it's substantially outweighed by the danger of unfair prejudice or by considerations of needless presentations of cumulative evidence. It was needless. You already had 8 others. The state did not argue that Dr. Flores' testimony was needlessly cumulative at trial, and the trial court did not consider this ground when excluding Dr. Flores' testimony. We review evidentiary rulings for an abuse of discretion, and on this particular ground, we cannot review a non-existent ruling. Okay. The state did, however, raise unfair prejudice at the trial. The state claims the trial court properly excluded the testimony because under Rule 403, the probative value of Dr. Flores' testimony was substantially outweighed by the danger of unfair prejudice to the state. Of course, the unfair prejudice cited by the state is the surprise arising from Jones's late disclosure of Dr. Flores. Okay, so I'm going to agree with that. If you had the information before the trial started, you've been in trial for 6 weeks, why are you over here at the last minute trying to bring her in? No. So, then it goes. Let's get back up here. Sorry. And it was unable to appropriately prepare for and respond to Dr. Flores' testimony. Jones argues he should have been able to use Dr. Flores' testimony to argue before the jury that Dr. Krause's scoring was faulty and perhaps misleading. Jones, as the proponent of Dr. Flores' testimony, had to establish its probative value. If the evidence had probative value, the state, as the opponent of the evidence, had to establish its probative value was substantially outweighed by the danger of unfair prejudice. We agree with Jones that the Dr. Flores' testimony had probative value because it included her rescoring of Dr. Krause's raw data in a way that purported to rebut Dr. Krause's conclusions of malingering. Having determined the evidence had probative value, we next review the trial court's ruling on the 3 fronts. First, the state prejudiced by the evidence. Here, the prejudice cited by the state was surprise. There's no question Dr. Flores' testimony was prejudicial to the state. After all, most evidence offered by one party before trial could have been secured by a qualified individual to review the raw data before Dr. Krause entered the fray in the 11th hour. Third was the probative value. Dr. Flores' testimony substantially outweighed the danger of unfair prejudice to the state. This is always a difficult question. We recognize trial courts necessarily process and rule upon objections in a rapid-fire setting, and we applaud the trial judge's immediate grasp of the state's objections to Dr. Flores' testimony. The trial judge quickly moved to the most pertinent objections, whether Jones presented Dr. Flores' testimony too late in the game. Implicit in the trial judge's exclusion of Dr. Flores' testimony is that the probative value of that testimony was substantially outweighed by the danger of unfair prejudice to the state. It's on this point we conclude the trial court erred. Okay, so they're calling that a mistake. They don't agree. It's an error, and because you can't do last minute surprise. Okay. But they agree that it should have been there because they could have used it and said, look, your scores could be wrong. Anyway, in State v. Mercer, we considered a similar challenge to the trial court's exclusion of expert testimony about a capital defendant's brain scan. Although a prior witness testified the scan showed questionable abnormalities, defense experts Dr. John Steedman planned to render a stronger finding of abnormality. The trial court excluded Dr. Steedman's testimony during the sentencing phase, finding he was a surprise witness and his testimony was unduly prejudicial. So both sides are just finding surprises for these people when they get into this penalty phase. On appeal, we concluded that the probative value of Dr. Steedman's excluded testimony was a matter of law, not substantially outweighed by its potential for prejudice as a result of the never issued formal discovery order. Second, both Steedman and the substance of his testimony were disclosed to the state before he was set to testify. Although we found the exclusion of Dr. Steedman's testimony error, we held the error was harmless beyond a reasonable doubt because the brain scan was admitted into evidence, another expert had testified as to the abnormalities, and Dr. Steedman was allowed to testify at length above the defendant's cognitive deficiencies and learning disorders. Does this sound like Mr. Tanner over here again? What are we doing? We emphasize that, Tanner Horner, that's his name anyway. We emphasize that our holding in Mercer does not stand for the black letter proposition that every criminal or civil case, a trial court's exclusion of tardy evidence is error under Rule 403. However, in this case, we hold as a matter of law that the probative value of Dr. Flores' testimony was not substantially outweighed by the danger of unfair prejudice to the state. The trial court should have allowed Dr. Flores to testify about her rescoring of Dr. Krause's data. That was also a harmless error. Okay, well, it's harmless, but they're still going to call it an error. Okay. Having determined that the exclusion of Dr. Flores' testimony was error, we must determine whether the error was harmless. We hold it was harmless, which is good. During the guilt phase, Jones presented 7 expert witnesses to testify in support of his NGRI defense. This testimony was incorporated into the mitigation witnesses during his sentencing phase. A summary of these witnesses' testimony is important, and this summary reveals that each defense witness who gave an opinion as to whether Jones was malingering stated quite unequivocally he was not. Richard Frierson, MD, is a general and forensic psychiatrist, a professor of psychiatry at the University of South Carolina School of Medicine. The medical school has contracts with South Carolina Department of Mental Health, which is the DMH, so Dr. Frierson regularly performs forensic evaluations at DMH's request. Dr. Frierson testified he interviewed Jones 6 times for a total of 19 hours and reviewed information from 295 sources. Dr. Frierson's opinion that at the time of the murders, Jones was sane or criminally responsible. And let's talk about that. Why was he sane and criminally responsible? When you have the forethought to go hide what you've done, you're sane. If you were not sane, you wouldn't care if this was found out or not. But he knew he needed to go hide all this and try to pretend like it never happened. What was he going to say? All 5 children ran off and he didn't know where they ran off to? Think about that. Yeah, I believe he was sane as well. It's so bad. It's just so bad. So, Jones was sane or criminally responsible. Jones could distinguish moral right from moral wrong and could recognize his actions as legally and morally wrong. Dr. Frierson testified that at the time of the murders, Jones had substance-induced psychotic disorders from smoking spice. Now, I've never smoked spice. I don't know anything about it, so I don't know if it could bring any kind of hallucinations or psychotic or anything. I don't know anything about it. Jones knew he had a family history of schizophrenia. Now, this is true. Jones's mother is a diagnosed schizophrenia. So I guess he was going to claim that he was a schizophrenic as well, and that's why he was not sane. And so anyway, the history of schizophrenia was convinced, and the drug-induced anxious thoughts that he was having were in fact schizophrenia. Dr. Frierson testified that he has practiced forensic psychiatry for 30 years. He has examined individuals who were malingering, and he was rather surprised that the test he conducted did not indicate that Jones was malingering. Dr. Frierson testified Jones was just trying to convince himself that he had schizophrenia so he could live with what he did. Okay, so see, I understand that. Yeah, he was sane. Because if he could blame it on his schizophrenia, then it wasn't his fault. Just like it wasn't Tanner Horner's fault either, right? It was zero. Remember that? Julie Dorney, MD, testified for the defense as an expert in forensic psychiatry. Dr. Dorney provided exceedingly detailed testimony of the same issue of insanity. She met with Jones 8 times before the trial, the first time being on the 3-year anniversary of the murders. Dr. Dorney testified that at the time of the murders, Jones suffered from psychotic symptoms, specifically delusional thinking and hallucinations. She testified this was a major or mental illness, and Jones was insane because he did not recognize the legal wrongfulness of his conduct and did not have the capacity to distinguish moral right from moral wrong. She further testified that after Jones killed Nathan, they misspelled it. After Jones killed Nathan, he felt the other 4 children would be better off in heaven than without their brother and not being with their parents. He felt they were better off in heaven. Is he Lori Vallow? And is he Chad Daybell? Is that what we got going on here? Dr. Dorney testified she always looks for signs of malingering and saw none in Jones. She testified that although the staff members from South Carolina Department of Corrections questioned whether Jones was malingering, the hundreds of pages she reviewed did not support a finding of malingering. During cross-examination, the state questioned Dr. Dorney about Dr. Krause's testifying. Dr. Dorney stated that Jones was not displaying symptoms of schizophrenia and at the time of Dr. Krause's evaluation, so she questioned why anyone would conduct malingering tests at the time. Dr. Dorney stated that malingering tests conducted by Dr. Krause are tools that you use if someone is actively reporting symptoms. At the time Jones saw Dr. Krause, he did not have any symptoms. Dr. Dorney characterized Dr. Krause's employment of the test as a misuse of the test. Again, she testified nothing would support the conclusion that Jones was malingering. I don't know much about that, but I'm just going to say, in my mind, if you have the wherewithal to go hide what you've done, you're sane. You know what you're doing. People that are having psychotic episodes, they just wake up. They don't know why somebody's dead over there. They don't know when this happened. They have no idea what's going on. All of a sudden they realize, oh my God, what happened here? They have no memory of it. He absolutely remembers what he did. He remembers. April Ham's PhD, Jones's marriage therapist, testified for the defense as an expert in marriage and family therapy. Jones's therapy sessions with Dr. Hams took place 3 to 4 years before the murders. Dr. Hams testified that during Jones's first sessions, Jones said he had a monster inside of him. Jones repeatedly referenced the monster in subsequent sessions. Dr. Hams testified that Jones came to her for help with anxiety, depression, and feelings of inferiority. She diagnosed Jones with recurrent major depressive disorder and unspecified non-psychotic mental disorder. Well, she's saying he wasn't psychotic. Okay. I'm trying to pronounce this guy's name. Bhushan Akor. It's Agharkar, MD. We're just going to call him Bhushan A. Testified for the defense as an expert in adult and forensic psychiatry. Dr. A testified Jones suffered from schizophrenia and minor neurocognitive disorders, the latter of which is commonly referred to as brain damage. Dr. A was very informative and detailed how schizophrenia manifests itself in those stricken with the disorder. He noted that Jones's mother is a schizophrenic, which creates in Jones a significance to genetic loading. For this disorder. Dr. A testified he's always considered the prospect of malingering, but determined Jones was not malingering based on his history, the brain damage, and symptoms in presentation and response to medications. Dr. A also testified that he requested the neuropsychologist Aaron Bigler, PhD, to review Jones's brain imaging studies. Oh my. Dr. Bigler testified for the defense as an expert in neuropsychology. Dr. Bigler testified he had particular expertise in looking at brain imaging methods and how to use those findings to relate to the behavior of the individual. Evidence introduced at trial established that Jones was involved in a car accident at age 15. The accident left Jones with a brain injury and visible indentation on his forehead. After reviewing Jones's brain imaging studies, Dr. Bigler testified he could immediately tell that Jones had a significant traumatic brain injury and skull defect. Dr. Bigler testified there is connections between traumatic brain injuries, schizophrenia, and ultimately that Dr. Bigler recommended Jones's brain imaging studies be reviewed by a neuroradiologist. Okay. Boy. Travis Snyder, MD, testified for the defense as an expert neuroradiologist. Dr. Snyder examined the MRI scans of Jones' brain and found a large left frontal depressed skull fracture, indicating that Jones sustained a severe traumatic brain injury at some point in his life. Among other abnormalities, Dr. Snyder found a thinning of the cortex and corpus callosum, which he testifies are associated with schizophrenia and schizoaffective disorder. Dr. Snyder testified that the frontal lobe injuries, such as the ones Jones sustains, often result in cognitive problems, personality changes, risk-taking, disinhibitions, and behavior spontaneity. Okay, look, we're going to talk about this for just a second. The only reason why I'm going to talk about this for a second is because I know somebody who had a traumatic brain injury. They wrecked a motorcycle and their head kind of hit the curb over there. When that person woke up, they were not the same person. I did not even know that person. was married to that person, but this was not the person I knew. He was somebody completely different. So I'm not saying this is what happened to him, but I am saying it's very possible that these things do really happen in real life. So they're not making up things. It happens. Donna Schwartz Maddox, MD, testified for the defense as an expert in forensic psychiatry. Her testimony was very detailed on the subject of schizophrenia and its cause and treatment. Dr. Schwartz Maddox testified she first saw Jones in the SCDC hospital on September 13, 2014, just 15 days after the murder. She testified there was no question in her mind Jones was clearly psychotic on that day. She testified Jones just met the diagnostic criteria for schizophrenia. On the issue of whether Jones' condition was substance-induced, in his case, whether it was caused by smoking spice, Dr. Schwartz Maddox testified most instances of substance-induced psychosis resolves within a month when the patient is hospitalized and properly medicated. She testified Jones remained in the hospital until the trial and was properly medicated but still had symptoms of psychosis. Dr. Schwartz Maddox testified that before the trial began, Jones was housed at SCDC and was prescribed very high doses of, Geodon, Geodon, which is an antipsychotic drug. However, when trial began, Jones was moved to the Lexington County Detention Center and his dosage was reduced to much lower levels. According to Dr. Schwartz Maddox, this caused Jones' psychotic symptoms to worsen, which lent legitimacy to her conclusion that he was not malingering. Dr. Schwartz Maddox testifies that she had not seen Jones intentionally fake his symptoms, and if anything, Jones was underreported of his symptoms. Man, this is a lot of expert witnesses. I mean, it's a lot. Beverly Wood, MD, Chief of Psychiatry at SDCC, DC, testified that for the defense as an expert in psychiatry. Dr. Wood diagnosed that Jones was with schizoaffective disorder and prescribed a medication regime that included aforementioned drug. Dr. Wood testified to Jones's family history of schizophrenia. Jones told Dr. Wood he had been hearing voices since he was 12 years old. Dr. Wood noted that Jones displayed flight of ideas, pressured speech, and the disregard for personal hygiene, all of which indicate mental illnesses. Dr. Wood testified that in the SCDC settings, a number of inmates faked mental illness for various reasons, but nothing led her to believe that Jones was malingering. Jones admits in his brief that he presented significant evidence to prove he was not sane at the time that he killed his children. According to Jones, Dr. Frierson, Dr. Dorney, Dr. Hams, Dr. A, Dr. Schwartz Maddox, and Dr. Wood produced significant evidence that he was mentally ill and not malingering. Additionally, the detailed explanations of Jones's brain damage given by Dr. Bigler and Dr. Snyder were front and center for the jury as mitigation evidence. In light of the extensive testimony that Jones was not malingering, we hold any error in the trial court's exclusions of Dr. Forrest's testimony was harmless. In fact, the only witness who suggested Jones was malingering was Dr. Krause. So, Dr. Doney directly challenged the propriety of Dr. Krause's administering the malingering test because Jones was not displaying symptoms of schizophrenia at the time. While only Dr. Flores rescored Dr. Krause's data, we hold the issue of malingering was exhaustively and fully addressed. Yes, it was. Yes, it was. This is crazy. Although Dr. Forrest's testimony would have purportedly cast doubt on Dr. Krause's scoring and allegedly flawed the approach to concluding Jones was malingering, Jones presented a wealth of evidence that he had brain damage and was schizophrenic and was not malingering. We hold it's not reasonably likely that Dr. Forrest's testimony would have affected the jury's decision to impose the death sentence. See Skippers versus South. Stating that sentencing phases of a capital trial, an error is not harmless if it appears reasonably likely that the exclusion of the evidence may have affected the jury's decision to impose the death sentence. Okay, so that didn't happen here. Therefore, the trial court's exclusion of Dr. Forrest's testimony was harmless. Number two, all of that for number one. Now we're going to go to number two. Limitation of the testimony pertaining to Jones's future dangerousness, remorse, and social history. Doesn't this sound just like Tanner Harney from the other day, doesn't it? As noted above, the admission of evidence is left to the sound discretion of the trial court, and generally, evidentiary rulings will not be reversed on appeal absent of prejudicial abuse of discretion. Whaley is one, so they would use that as a citing. Although the Eighth Amendment recognizes the capital defendant's right to present mitigation evidence, the right is limited by general evidentiary principles. See Jurek versus Texas and Mercer. Specifically to admissible mitigation evidence, it must be relevant. Lockett is one. Payne versus Tennessee. See State versus Northcutt. Okay. The meaning of relevance is no different in the context of mitigating evidence introduced in a capital sentence proceedings than it is in any other trial. McCoy versus North Carolina. Evidence is relevant if it has any tendency to make the existence of any fact that is of the consequences to the determination of the action more probable or less probable than it would be without the evidence. Rule 404 Rule 401 SCRE. Yeah, okay. Evidence that is not relevant should be excluded. See Rule 402 SCRE. In the context capital sentencing, if the sentencer could reasonably find that the mitigating evidence warrants a sentence less than death, then the Eighth Amendment requires that the jury be able to consider and give effect to the evidence. Kennard versus Drake, cleaned up, first quoting McCoy versus in the United States, and then quoting Boyd versus the United States. Future dangerousness. This is always a good one right here. During the sentencing phase, defense counsel proffered the testimony of Sergeant Barry Sowers. Sergeant Sowers testified about an encounter he had with Jones while transporting Jones from Mississippi to South Carolina. According to Sergeant Sowers, an automatic weapon on his lap. Oh, wait a minute. According to Sergeant Sowers, when he and the extradition team stopped at a rest stop, the other team members went inside, and he remained in the vehicle with an automatic weapon on his lap. Noticing the weapon, Jones told Sergeant Sowers, "You guys don't need an automatic weapon for me. I'm not going to hurt you." Sergeant Sowers replied, "These weapons are not for you in particular. They're for everyone trying to kill you." Okay, how about that? I'm sure that shocked him. Defense counsel sought to introduce Sergeant Sowers' response as mitigating evidence that Jones did not present a risk to future dangerousness. After hearing Sergeant Sowers' proffered testimony, the trial judge ruled, "You can get Tim's response in, but Detective Sowers' response to me, his personal opinion and not relevant to Mr. Jones's character in any way. I think it goes to Mr. Sowers' training as an officer that his job is to protect him. It is Mr. Sowers' character." Okay. Weird. We affirm the trial court's ruling that Sergeant Sowers' proffered testimony was not relevant to Jones's future dangerousness. The testimony reflected that Sergeant Sowers' speculative opinion about how the public perceives Jones. It was not based on Sergeant Sowers' own perception and nothing to do with Jones's actual dangerousness. And then we go to the remorse. Did he have remorse? I don't think he did, but we'll see. Before the jury, Sergeant Sowers testified he had been with Jones throughout the entire trial. Defense counsel classified Sergeant Sowers as Jones's handler and then asked whether he witnessed Jones crying during the trial. Sergeant Sowers replies, "Yes," upon which the following exchange took place. Defense counsel says, "Do you believe that there are those are crocodile tears?" And the deputy solicitor says, "Objection, Your Honor, speculation." The court says, "I sustain the objection." Defense counsel then says, "When you've seen him crying, do you believe that his remorse is real?" And then the court says, "I sustain the objection." And oh boy, this is wild. Then the solicitor says, "Objection, speculation," and the court again says, "Sustain." Okay, so the defense counsel argued that Sergeant Sowers' testimony demonstrated Jones' remorse, and at no point, however, did defense counsel proffer Sergeant Sowers' responses to these questions. Even assuming that Sergeant Sowers would have testified that he thought Jones's tears were real and Jones's remorse was genuine, we hold any error in excluding his testimony is harmless. A fleeting mention of Jones's remorse, if admitted, would not have affected the jury's decision to impose the death sentence. And he's right about that. It would not have. Now we're going to get to social history. Remember the social history the other day? Oh boy, all the teachers and... When Roberta Thornsbury, Jones's paternal grandmother, testified during the sentencing phase, defense counsel inquired about her life before Jones was born. The state objected, upon which the trial court excused the jury. noting that he consistently directed that the defense to only ask questions from Jones's birth forward. In the guilt phase, the trial judge asked the defense counsel why his ruling should differ in the sentencing phase. Defense counsel responded by requesting to proffer Thornsberry's testimony. The trial judge allowed the proffer, and Thornsberry's testimony detailed a family history of abundant incest, abuse, and exploitation. Okay. Although the trial judge recognized that evidence of Thornberry's horrific childhood certainly impacted Jones to some degree, he ruled that such evidence would be irrelevant to Jones's character and would therefore confuse the jury. I agree with that too. It's not about her, it's about him. The defense counsel objected to the ruling, and the trial judge clarified that Thornsberry would be allowed to testify generally about her childhood from broken home and traumatic history, but would not be allowed to testify about intimate details that were irrelevant to Jones's character. Anticipating the trial court's ruling would equally apply to the testimony of Jones's father, Timothy Ray Jones Sr. Now, I'm going to say this. I saw Timothy. Okay, so there is a show on A&E. It's called My Child the Killer. This case was on that show, and I listened to Mr. Jones talk about his son and how disappointed he was, and how that he thought he saw something but didn't see it quick enough. In other words, he thought something was wrong, but was not able to do something about it quick enough. So, Timothy Ray Jones Sr., defense counsel proffered Sr.'s testimony. Sr. explained how his childhood was marked by fear, violence, trauma, and mental illness, physical abuse, and substance abuse. At the end of the proffer, defense counsel again requested that the jury be permitted to hear testimony about the events occurring before Jones's birth. The trial court did not allow this testimony. That's kind of like in the Tanner Horney case when they were talking about, the alcoholic syndrome. Remember, his mother was drinking when she was pregnant? Defense counsel also proffered the testimony of Deborah Gray, a social historian. The disputed portion of Gray's proffer began with Thornsberry's childhood and continued until Jonesbury's birth. It largely tracked Thornsberry's and Senior's proffers, albeit with more expansive details, and the conclusion of Gray's proffer, the trial judge made the following statement. I want to think of a way and suggest to you all to come up with a way for this lady to say this lady's summary of Miss Thornberry's mental history. Mrs. Turner, Cynthia Turner's history, without going through every single minute or detail. All the social psychologists and the psychiatrists said that the Jones family had a huge bunch of illnesses, medical, suicides, physical abuses, sexual abuses, and I think she can say things like that without saying that the grandma was sexually abused 18 times by the time she was 6 years old, because that really has nothing to do with Mr. Jones, right? The trial judge later instructed the defense counsel to use a broader brush rather than a detailed brush, and to present some mitigating facts without becoming the Dr. Phil show. It's not funny, but that's a funny statement. The trial judge continually advised the defense counsel to give the facts but avoid the details of each fact. Put up some rails on the alley where you don't go into the gutter. If you get too detailed, I'm going to say move on. Before the jury, Gray was permitted to testify extensively about Jones's family history. She testified that both the paternal and the maternal sides of Jones's family were littered with attachments and protection issues. She recounted that the rape, torture, abandonment, trafficking, and substance abuse, domestic violence, and mental illnesses Jones' caretakers endured, and opinion that it was the family dynamic into which Jones was born. Nonetheless, Jones argues that the trial court erred in forcing him to deliver a condensed and sanitized social history and repeatedly instructing Gray to move on. When her testimony became too detailed, we disagree and therefore affirm the trial court's limitations. Although events occurring to Thornsberry and Sr. before Jones's birth undoubtedly shaped their parenting methods and family environment, these events were irrelevant to Jones's character. In our view, Jones disregards the requirements of that evidence of a defendant's social history be relevant and concerned with a defendant's character or record. Okay, now let's go down here. We expressly held that the Eighth Amendment does not deprive a sovereign of its authority to set reasonable limits upon evidence. A capital defendant can submit and control the manner in which it is submitted. Alteration in original, quoting Oregon versus Guznick, it would be far too remote to conclude the external events impacting Jones's family members before his birth directly affected Jones' own character. If anything, these events affected the character of Jones's family members an issue that was not before the jury before the sentencing. See, I agree with this too. I mean, we've all had bad childhoods, but that doesn't make us kill our own children, does it? No. We've all seen people whose parents were schizophrenic, mental, whatever, but they did not go out and kill people or their children, did they? Just because you had a bad childhood does not make it okay for you to take the life of somebody else. No, I disagree. Okay. Even assuming the trial court erred by limiting this testimony of Thornberry Sr., any error was harmless. Gray was permitted to testify considerably about Jones's family history, including all relevant details. For these reasons, we affirm the trial court's limitations. Exclusions of Cynthia Turner's pre-recorded testimony. Okay. During the sentencing phase, defense counsel sought to publish the pre-recorded testimony of Jones's mother, Cynthia Turner, as the mitigating evidence of Jones's state of mind and mental illness. In the recording, Turner was unable to recall basic facts about her personal history and appeared to detach from reality. His mother is schizophrenic, right? She's in a hospital. Of course, she has to have pre-recorded, and she's not going to be able to recall some of these things. Turner also claimed she did not know Senior, even though she dated and was married to him for 5 years. Turner was unsure why Senior was awarded primary custody of Jones after their divorce, and she did not remember giving birth to one of her other children. When asked how she felt about Jones, Turner replied, "He's a nice kid, but I don't understand how he did that about his kids." So see, I mean, you can't rely on what she testifies to. She was mentally ill herself. Noting numerous experts had already testified about Turner's mental illness, the trial judge questioning the relevance of her testimony. Defense counsel responded, "It's his mother who is diagnosed with schizophrenia, and which the number of other people have diagnosed him with, and what condition Tim could end up in. It is his future." The solicitor countered that Turner's testimony was prejudicial because it was unclear whether her exhibited symptoms were signs of schizophrenia, manifestations of other disorders, or medicinal side effects from medication she was taking, or the following exchange. And then they said this, good Lord. Defense counsel's mitigation is any reason not to give death. The fact that his own mother couldn't come to his trial is likely a reason for a juror not to give death. The court, how are you prevented from arguing that right now? The defense counsel says, I am not. The court, all right, I'm not letting it in, and then you talked to me into it. So he wasn't going to allow it, now he's going to allow it. This is wild. The court, all right. Defense counsel, we object under State versus MRSA, and the relevant mitigation should be admitted under at 403 shouldn't be used to exclude mitigation evidence. The court, in its broader 403, says that video was done late. It was done during jury selection. There's too many things that are unknown with her medical condition, and the state is not challenged whatsoever that she has a severe mental illness. And she's institutionalized. All that's free game for you to argue that she couldn't come for those reasons. She was not allowed to come, so you are certainly welcome to argue that. I think it's inflammatory, and I don't think it's proper to be introduced in this phase of the case, so I'm not going to allow it. We affirm the trial court's ruling that Turner's testimony had no probative value and the risk of confusing the issue to be decided, which was Jones's mental health, with the issue that was demonstrated by this testimony. Turner's own mental state. Jones's claims, which is Welk versus State, supports the recording of admissions because Turner's bizarre behavior would have corroborated the defense's mental health expert's description of schizophrenia. However, Jones' reliance on Welk is misplaced. In Welk, the defense counsel conducted numerous pretrial interviews with defendant's family members, co-workers, and acquaintances, all of whom revealed his childhood was traumatic, filled with emotional and physical abuse at the hands of his psychotic father. Despite abundant evidence, the defense counsel presented only one mitigation witness, the defendant's sister, who provided extremely limited testimony, which was general and vague, and offered no detail on the insight into the degree of abuse that the defendant suffered as a child. We remanded the case for a new sentencing trial because the evidence presented by defense counsel fails to sufficiently reveal the defendant's abusive and dysfunctional childhood, as well as his genetic predisposition to schizophrenia, and hallucinogenic symptoms at the time of the crime. Unlike Welk, Where defense counsel presented minimal testimony about the defendant's abusive family and background, Jones's extensive social history was elicited through the testimony of Thornberry Sr. and Gray. While the social history testimony in Welk spanned merely 3 pages of the trial's transcript, the testimony here was set forth in more than 100 pages in the sentencing phase alone. Jones argues that at the very least, Turner's testimony bore on mitigating factors related to his mental state. However, Turner's testimony was relevant to her mental state, not Jones's. Neither Turner's diagnosis nor hereditary nature of schizophrenia was disputed. We therefore affirm the trial court's exclusion, and I think it was right too. I don't think his mother should have been paraded. Her testimony should not have been paraded around that she was in a mental institution and that she was schizophrenic, and that, you know, she didn't even know her ex-husband. That's just wrong on all sides. Admission. Oh, now here's the big part. Now, one of the biggest problems here was the admission of the autopsy reports of the children, because they were in very bad condition when they were found, and the defense is trying to say, well, that just they were going off of feelings. That just prejudiced them against the defendant, because look at the condition of those kids, and you're playing on their hearts, right? During the sentencing phase, the trial court admitted, over Jones's objection, 10 autopsy photographs, 2 per child. The issue before us, whether the probative value, if any, of the photographs was substantially outweighed by the danger of unfair prejudice under Rule 403. Jones argued at trial that the photographs were inadmissible under Rule 403 and 401 because the state had already proved the existence of statutory aggravating circumstances, and the absolutely horrific and nightmarish photographs would do nothing more than arouse sympathy or prejudice. The solicitor responded that the photographs show Jones's character. Oh my gosh. That the work of his hands, okay, because they depict the bodies of the victims in the same condition he left them in, or conditions he left them to become in. The solicitor argued that the photographs were relevant to show how Jones bagged up his own children's bodies, drove them around for more than a week, and deliberately left them in the hot sun to accelerate the decomposition. Okay. After reviewing the cases cited by both parties, the trial judge allowed the state to admit the 2 autopsy photographs per child, citing several cases along with Rule 401, 402, and 403. The trial judge determined the photographs, even though they're very unpleasant, were probative of Jones's conduct of packing the children in bags and contorting their bodies in different fashions, putting them out there in the woods. Over Jones's objections, the photographs were admitted during the testimony of expert witness Dr. Janice Ross, the forensic pathologist who performed the autopsies and took the disputed photographs. Dr. Ross testified during the guilt phase and was recalled by the state during the sentencing phase for the purpose of having the photographs admitted into evidence. Although Dr. Ross described what was depicted in each photograph, the solicitor did not publish the photographs in open court, out of what the solicitor stated was his respect for the jury. Dr. Ross testified that Elias's cause of death was asphyxia due to strangulation. Gabriel's cause of death was homicidal violence with probable strangulation. Mariah's and Abigail's and Nathan's death were homicidal violence. Dr. Ross testified there was a wound to Nathan's knee, which was depicted in the photograph published during the guilt phase, that appeared to be caused by a sharp instrument, likely a saw or a knife. And I'm going to tell you why. Because after this, he went to Walmart and he bought a bunch of things, and one of the things he bought was a saw. I think he was going to attempt to cut their bodies up, but once he started, he could not do it. That tells you he wasn't psychotic. He was very sane. He knew exactly what he was doing. Damn, it's horrible, guys. It's horrible. After Dr. Ross's testimony, the defense counsel noted the state needed the photographs to show Dr. Ross in testimony, and they were not used for that purpose, which enhances the fact that they're just being used to create emotional impact. The defense counsel then moved to have the photographs kept in the courtroom during the jury deliberations so that the record could be made. So the record could be made they would not have any emotional impact. The photographs that would evoke, let me read this. Hang on. He did not want, so during the jury deliberations, so a record could be made of any emotional impact the photographs have evoked in a juror if they're asked to see them. The trial court denied this request, and then the photographs went into the jury room along with the other trial exhibits, which that's fair. That's what you should do. The determination of the relevancy and the materiality of the photographs is left to the sound discretion of the trial judge, whose rulings will not be disturbed absent of showing a probable prejudice. Stephen versus Connorans, there's a bunch of, In the sentencing phase of the capital trial, photographs may be offered as extenuating, mitigating, or aggravating evidence to direct the jury's attention to the specific circumstances of the crime and the characteristics of the offender. State versus Halsden. It is well established that the photograph calculated to arouse the sympathetic, It is well established that this photograph, calculated to arouse the sympathies and prejudices of the jury, are to be excluded if they are irrelevant or unnecessary to the issues of the trial. State versus Middleton, in which the defendant, these photographs are relevant if they depict the bodies of murder victims in substantially the same condition in which the defendant left them. This is again, there's another case they stated. Even if it's relevant, photographs are unfairly prejudicial if they create a tendency to suggest that the decision on an improper basis, commonly though, not necessarily an emotional one. State versus Franklin. Boy. In several capital trials, we have considered the admissibility of autopsy photographs. We explained in Franklin that the criteria is not the photograph becoming inadmissible because they're graphically and they depict a gruesome scene. Rather, the question is whether the photographs are unfairly prejudicial so as to outweigh the probative value. We noted the autopsy photographs in that case were highly relevant to the issue of physical torture delivered upon the victim by the defendant. And photographs in this case were highly relevant to the issue of the physical torture delivered upon the victims by the defendant. In Middleton, we considered a challenge to the trial court's admission of photographs showing the victim's scalp pulled away. Okay, trigger warning. Some of this I didn't know was in here. Oh, God. Pulled away from her skull and her surgically open, oh, my God. BJ cavity filled with, oh, my God. I'm not going to say that. Okay. Because it was clear the facts were not in dispute, and because the testimony of the forensic pathologist negated any arguable evidentiary value of the photographs, we held that the prejudice created by the photographs clearly outweighed any evidentiary value. 9 months after deciding Middleton, we decided that in Cornrens, the trial court admitted several photographs during the sentencing that depicted the autopsies of 2 murder victims. Photographs of one victim showed her lying on an autopsy table in the same condition her body was found, and photographs of the other victim showed the knife wounds to his chest, back, and thigh. We concluded that the photographs were properly admitted because, while not pleasant to look at, they showed what the defendant himself did to the bodies, and the bodies were not altered by decomposition or by any other outside force. More recently, we considered a challenge to the trial court's admissions of several autopsy photographs during the sentencing. Each graphically depicted the injuries of the victim. State versus Torres. We acknowledged that some of the photographs were close-ups of the victim's injuries and were graphic in nature, but we concluded that the purpose of the close-ups was to help identify the nature of the particular injury and show what the defendant did to the victim, which goes straight to the circumstances of the crime. We upheld the trial court's admission because, although the crime was particularly horrific, the admission of the photographs did not unduly prejudice the jury. Despite affirming the trial court's growing concerns in the admission of autopsy photographs, we strongly encouraged all solicitors to refrain from pushing the envelope on admissibility in order to gain victory, which in all likelihood was already assured because of the substantial evidence in the case. See, I agree. After Torres, we again considered admissibility of horrendous autopsy photographs, albeit in a non-capital trial. See State versus Collins. In Collins, the defendant was indicted for several crimes arising from a 10-year-old boy being mauled to death by the defendant's unrestrained dog. Oh, God. At trial, the state offered into evidence a group of pre-autopsy photographs taken by forensic pathologists that demonstrated the dangerous propensities of the dog, the manner and the extent of the attack, and the defendant's criminal negligence. Nature and extent of the victim's injuries were in dispute, and the photographs showed the boy's exposed jawbone. Okay, trigger warning, I'm so sorry. The exposed jawbone and the upper arm bone and the areas where the chest and face had been partially eaten during the dog attack. Okay, just a minute. The trial court admitted the photographs and the Court of Appeals reversed, holding that the probative value of the disturbing and gruesome photographs were substantially outweighed by the danger. I'm sorry, hold on. This is horrible. I did not read this before. I did not know this was here. In Collins, we acknowledged that the photographs were graphic, but we concluded they were highly probative. I'm going to skip this, okay? Even assuming the photographs had some probative value because the purport to show Jones's character through the method and manner in which he bagged and disposed of the bodies, we hold as a matter of law that under Rule 403, such a value. I'm sorry, hang on. Damn.
Take a breath. This man is an absolute monster. Just a monster. The fact that he murdered his kids, but murdered them in this vicious way, there's absolutely no reason that man should get an appeal. I mean, it's just it's absolutely atrocious. It's one of the worst ones I think ever. I really do.
And the fact that they're using these other cases as to try, oh my God, why these cases? These cases don't even match. I mean, they're bad, but they don't even match what he did. They just don't. I mean, but I mean, when you're trying to get an appeal, yeah,
they're grasping at straws, is what they're doing.
I think so too. All right. I think what Jones is trying to do is basically use shock value to diminish the shock should there be a second half of this case. In the second phase of this case, we get to show the characteristics of the crime, the defendant, and how the victims were found. The photographs become probative at that point, relevant at the point right now they're not. Okay. The solicitors.
Well, he's trying to say, yeah, look at what I did was bad, but I was just as bad as so and so. No different.
Right. Oh. Damn it. The solicitor's words to diminish the shock are even more indicative that the probative value of the photographs was substantially outweighed by the danger of unfair prejudice. We observed in Taurus that the photographs calculated to arouse the sympathy or prejudice of the jury should be excluded if they are irrelevant and not necessary to substantiate material facts or conditions. Based on the record before us, we hold photographs had no probative value. We hold that even if the photographs had probative value, the broader probative value implicated by Conrans was substantially outweighed by the damage of unfair prejudice to Jones. Okay. Harmless errors. This is better. Having determined the autopsy photographs were admitted in error, we must determine whether the error was harmless. There is no question that the murders perpetrated by Jones was horrific, perhaps the most horrific and unimaginable. After running 6-year-old Nathan to death, Jones strangled 7-year-old Elias to death, while Elias begged Jones not to kill him. Jones strangled 8-year-old Mariah to death, while she pleaded, "Daddy, I love you." Jones strangled 1-year-old Abigail and 2-year-old Gabriel to death with a belt because their necks were too small for his hands to fit around. Jones then packed his children's bodies in plastic bags, stacked them in the back seat of the vehicle, and drove across several states, all while trying to decide what to do. As he drove,
I remember when he was arrested. I remember seeing it on the news. Yeah.
It was terrible. This is terrible.
Yeah. He's just a monster.
And
I don't know how the mom just goes on. I really don't. I
don't either.
Like you say, her testimony was just heart-wrenching. Just heart-wrenching.
As he drove,
and then to sit up there and say, you know what, it's not my decision for him to die because his children loved him. And I was just like, oh my God.
Yeah, that's horrible.
God. Oh my God, that woman.
Horrible. Yeah. As he drove, Jones bought spice, trash bags, chemicals, goggles, a dust mask, and a jab saw. Okay, remember the child had a cut on its knee? That is what he was attempting to do with his jab saw. He searched the internet for applicable extradition laws and local dump sites, landfills, and campgrounds. He wrote a note reading in part, melt bodies, sand to dust or small pieces, and day 1, burn up bodies. Day 2, sand down the bones, and day 3, Mexican border, with a smiley face. Dissolve and discard. His expressions of happiness about escaping to Mexico is particularly compelling. While the autopsy photographs should not have been admitted, we properly take note of Jones's calculated efforts to dispose of his children's bodies in a remote area to evade responsibility for what he had done. He's absolutely sane. Absolutely.
Oh, yeah.
God, man. If you look, people who are psychotic or are insane, they don't go through all of this to get rid of the evidence. They don't. They just like, what do you mean I did that? I don't understand. I don't remember. It's foreign to them. It's foreign to them. They have no recall of it. When the autopsy photographs are horrific, absolutely. Were they inadmissible under Rule 403? Yes. For the reasons we have explained, however, after weighing the horrific facts of this case against the improper admission of the photographs, we hold that the photographs did not contribute to the jury's sentence of death. See Skipper 476, and there's the citing for it. Proportionality review. Pursuant to South Carolina's Code Section 16-3-25, we must conduct a proportionality review of Jones's death sentence. We find the sentence was not the result of passion, prejudice, or any other arbitrary factor, and was instead supported by the aggravating factors alleged by the state. As set forth in the subsections 16-3-20, murder of 2 or more persons by one act or pursuant to one scheme or course of conduct, and murder of a child 11 years of age or younger, with the possible exception of State v. Wilson, in which the defendant was sentenced to death for murdering 2 8-year-old girls on an elementary school campus. There is not a comparable case to the one before us, and frankly, the horrific murders perpetrated by Jones are incapable of comparison in this state. And that's, oh God, yeah, okay. Therefore, Jones's death sentence is neither excessive nor disproportionate. Conclusion, we're to the end. For the foregoing reasons, we affirm Jones's conviction and death sentence. Affirm. Beatty C.J. Kittredge Beatty, the criminal justice, acting Justice K. Oh, I can hear that. All right. Concurring in a separate opinion. Justice Few. I concur in the majority of the opinion, all respects except as the subsection B4. I would hold the trial court acted within its discretion to admit 2 autopsy photographs of the badly decomposed body of each child, and thus the admission of the photographs was not in error under Rule 403 of South Carolina rules. The majority is correct. The photographs are gruesome and were certain to cause forceful emotional reactions from the jury. Like the other justices I have seen and sat these photographs, it is not possible to describe them. They are literally unbearable. A death penalty trial, however, like as a heinous murder of his own children, itself is gruesome business. And even without the photographs such as these, the evidence of what this man did to his children certainly caused a forceful emotional reaction from the jury. There is hardly anything unfair in allowing the jury to see, not just hear, what this man did to the bodies of his children. It is simply not possible to sanitize the murder of these 5 innocent children, nor for the matter the trial of the man who did it, nor certainly the evidence of which the state seeks to convince the jury to kill that man through the death penalty. Timothy Ray Jones Jr. took a long series of planned, deliberate actions, first to murder his own children, then to conceal the vicious crime, and finally to leave the bodies of his own children for the purpose of having them deteriorate to the conditions shown in the photographs. His crimes were unspeakable. His efforts to get away with his crimes were unconscionable. He is despicable. The photographs show all that, and thus the photographs have probative value. In my view, the trial court determination that the probative value of the photographs was not substantially outweighed by the danger of unfair prejudice was reasonable decisions, and within the trial court's discretion, I would find no error. Woo! Footnotes.
Well,
So
what are they trying to say, that if the photographs are too gruesome, then we don't show them to the jury. There's going to be a white line of what photographs you can show in court and what photographs you can't. I mean, that's just asinine to me. You
Well, it's a
can't
matter of
you you can't censor a crime scene photograph.
no, you can't. But they felt like some of them feel like, well, even though it was an error, you may have like if your jurors may not be able to separate emotion at that point from rule of law, because they've seen this,
Right.
you know.
Yeah, no, I get that, but you can't. Can you imagine if that was some kind of ruling? Who would determine which photographs were acceptable to show in a court of law and which ones weren't? If they're, you know what I mean? You can't. It's not a gray area. That's a black or white area. You either show them or you do not.
I
You
have never
can't.
seen a case where they didn't, you know.
Right. That's what I'm saying. So it's like what was their final goal there? Like, oh, well, these were just too explicit. Well, I'm sorry. Anytime a body is murdered and manipulated and stabbed and all the horrible things that go with that, that you're already in that realm of being offensive and emotions being involved. I
Right.
don't care if I mean, what if you have a 6-week-old baby with one stab wound? That's going to bring out a tremendous amount of emotions in someone because it's a small infant compared to an adult that has one stab wound. There's, it's you know what I'm saying? It's an
Yeah.
apples to oranges argument. You're going to have the emotions, and anybody that has any human is going to have an emotion to seeing a murdered human, period.
Right. They
Your
are. I
emotions are
mean,
going to be a little bit more heightened with the brutality that you see in the photographs. Yeah, I get that. The more brutal, the more we wonder, like, God, those people suffered, how heinous. There's a lot more emotions that go in it when the brutality increases. However, anybody that's a normal, like I say, human being, there's going to be emotions involved in looking at those photos.
you know, I understand them not showing to the public who are sitting in the
Oh,
courtroom
yeah.
watching the trial, because courtrooms are open to the public, right? You know, you can
Yeah.
anybody can go
Oh,
watch any trial,
absolutely.
and no, those don't need to be shown there, and they don't need to be released if somebody does a FOIA for this information. You don't release them there either. They should
Absolutely.
not. They should be taken
Especially
out. But
in today's world with social
oh
media
God,
and all of that.
yeah, yeah.
Absolutely not.
You know, people
Back in
putting
the
it behind a
day,
paywall.
yeah, back in the day, if somebody was in a courtroom and saw those photographs, that's where they would stay, period. Now, like you say, there's the FOIA, there's all the different things where all of those photographs could come out. I mean, I just don't feel like any kind of crime scene photos that depict another human body should ever be released in a FOIA in any manner whatsoever. That needs to stay, period, just in the courtroom.
You know, well, you got to think about the dignity of the person. I mean, they're already, they've already had everything about them displayed all over the place. Why do you need to do that? You don't. And I mean, I can understand. I just feel like when you are giving somebody the death penalty, they already saw them in court, right? And but it's evidence. It's part of the evidence. So if they have any questions, they are allowed to take that. The evidence goes back to the jury room with them. The evidence is right there in case they want to look at something. They can go back and look at
Right.
it. And I think if you don't have the evidence there and you have questions, then you're also not doing your job. So
I
I
agree.
can see you. There's no way to just say, "Oh no, we're not going to put all the evidence back there. We're only going to put part of the evidence back there." Yeah, there's no way to
Yeah.
separate it like that.
Yeah.
Yeah, right,
And see,
right.
I'm just a huge proponent of if you kill a child, you get an
Mm-hmm.
automatic death penalty with no appeals. Period. That's the way it needs to be. That's the way it should be. You are automatic death penalty and you die. Period. There's no 14,000 appeals. There's no this. There's no that. There's no wasting time. You. That's just. I don't know. It will never happen. It would never happen. But that's the way I feel it should be. You murder a child. That's it. Done. Done. And I don't know if that would stop any of this, if it would reduce it, probably not, because the people that are committing the crimes, they're not thinking, oh God, if I kill this child, then I may get the death penalty. That's not going through their brains.
Right?
I just think laws in regards to children
Oh shit.
really need to be re-examined and really need to be redefined. And I think it should be universal across the United States. I don't think it should be different in Arizona than it is in New York, than it is in Massachusetts. I think it should be just universal, plain and simple.
Right. All right. I mean, but because they let. I mean, you've got your federal laws. You know, that's the United States Supreme Court. But then each state has their own state laws that they go by.
Yeah,
And you know, not every state has the death penalty either,
I
for
know.
whatever
I know.
reason. And I think I don't understand. I don't know why it's like that. I guess somewhere back when they were. I don't know why. But let me see if I
Well,
can find
probably when
something.
all, I mean, you have to think about it. When all these laws were created and the Constitution was created and all of this was created and states were created and the state laws were created, our world was so very different than it is now. I don't think anyone at that time could have ever even imagined or even thought up the fact of how violent our country would become and how
Right.
these things would happen. There was no, there was no, well, if this happens, then let's do this. It's just, I mean, it's different now than it was 50 years ago. Let's just be honest. It's different now than it was 25 years ago.
Right.
Things are
That's true.
so incredibly different. So, I mean, we have to go by the laws that are in effect, other than if, we can change things at a state level. But, to do that, I mean, you have to be able to turn black into white, and nobody can do that. It's just so much. You can change certain things at certain levels, like with the Gonzalez, they're able to change the law that that those photographs are not allowed to be shown elsewhere. I mean,
Oh,
there's
that's
small
right. I
things that
forgot
we can
about
do.
them. Yeah. Yeah.
Yeah,
Forgot about
and
her.
I
Yeah.
think that's, yeah, I think that's great, and as I think it should, that shouldn't even be a question. That should just be, why do we even have to take that step to make those things happen? Just like the whole thing with Zab Girl, when Gannon's
Oh God, yes, yes.
pictures were sent
Mm.
out in her FOIA. A,
Uh-huh.
they should have never been sent. They should have never been released to her, whether or not they were in the FOIA. And B, she should have never been allowed to post them, even on Patreon. There should have been, I mean, YouTube watches how many times your eyelids close during the day. You can't tell me there's nothing that they can put into the system that can show what's on Patreon and block that stuff. I mean,
Right.
it blows my mind.
I know it does me too. But I
And
think.
there's,
Go ahead.
I'm sorry,
You're
I'm
fine.
just so riled up. What
Mm.
what we know what happens. Why do we need to see pictures of a deceased body? What is with the culture nowadays where people want to see that? They
I
want
think
to
it's
see
because
the devastation to a human body.
I think it's because we watch too many horror movies. There's too many horror movies, and so it's almost like these things are just every day for us. They don't affect us in the same way that
We're
they would
we're
20
des-
years ago,
we're
right? We're
we're
desensitized.
de-
Yeah.
we're desensitized. Get out of my head as a culture. Yeah, you said it before I did.
Right. I know. But I think I know why every state does not have the death penalty. There's the risk of executing innocent people, and then there's the cost because you have to do so many appeals when you have a death penalty that the cost just every
Oh
time
yeah,
it is. I mean, it's just huge. I don't know what the full, there's the political and the cultural differences between the states. There's Supreme Court constitutional issues that comes along with the death penalty. There's just so many. I can see why some states would not want to put themselves at risk for that, uh, for those problems to arise.
yeah,
Because
but
you're talking about five
just
hundred thousand dollars for a trial. Yeah.
to play devil's advocate, even if you're not in a death penalty case, you still have the right to appeal.
Right.
So there's still going to be the cost of an appeal in a case that's not that death penalty. I just Googled the cost of a lethal execution in the United
Mhm.
States. Lethal executions in the United States are highly expensive, with total costs spanning investigation, trial, appeals, and incarceration, typically ranging from 1 million to over 3 million per case, significantly higher than life imprisonment without parole. While the drugs alone cost under $100, specialized procurement, staff overtime, and facility security often inflates costs.
Right.
Capital trials are 2 to 5 times more expensive than non-capital cases due to longer proceedings, which is back exactly what you just said, and increased legal representation needs. Drug procurement, some states pay $1,000 markups to obtain the drugs. Recent examples including $90,000 for phenobarbital in
Wow.
Indiana in 2024 and over $15,000 for drugs in Idaho. Executions require substantial staffing, also putting the prisons on lockdown, which adds costs for specialized security and boxed meals. States are spending heavily on renovations, such as Idaho's estimated 1 million, which doesn't sound like a lot for an
Right.
upgrade in a facility. Estimated 1 million upgrades for firing squad capability. So that's surprising to me that that's only $100. I mean, I know Idaho is doing the whole firing squad.
Oh God. Can you
Research
imagine?
shows that the death penalty imposes a net cost on taxpayers. In Texas, a death penalty prosecution can cost about 2.3 million. In California, it costs the taxpayers over 117 million annually at the post-conviction level.
Hmm. You know, I
So
found
again, it comes down to money.
this list of people that they think may have been, and this is deathpenaltyinfo.org, may have been wrongfully convicted. Okay. Texas, Carlos de Luna,
Yeah, I
executed
know.
in
We talked about that before. We did.
yeah,
But you have to remember too, a lot of those people when they were and I'm not saying it makes it right, and I'm not lessening that, because you know how I feel about that. I feel horrible.
right.
I feel some kind of way about people executed that don't deserve it. But a
Right.
lot of times those people, when they were convicted, we didn't have the same things that we have now. So many of these
Right.
cases, the DNA can be retried, or not retried, reinvestigated. A lot of the things can be redone before somebody is actually executed.
But you know what? A lot
I
of the
don't know. I
states will not allow the testing, like with they're on death row.
know
It's crazy how
they
they
won't
don't.
allow it to be retested. I
I
know.
don't understand that.
hmm
I mean,
I don't either.
this
Especially
is
if you're
innocence.
taking someone's life. Why
Right.
would you
Right.
not want to make 100% that you have the right perpetrator? That doesn't make sense.
No, it
It
doesn't. It
blows my
doesn't.
mind.
Yeah. I think
It there's so much reform that needs to happen. I mean,
well,
so
the
much
death.
reform.
Death penalty cases are that's the most controversy thing in the United States. I
Oh
mean,
yeah.
it's more controversy than people with EBT cards, etc., because of the
hmm
possibility of the mistake. And we know there have been mistakes. We know there have. I mean,
Of course. I mean, at
nobody
the
wants
end
to
of
be
the
the one that's
day,
responsible for that, right?
people. At the end of the day, we are humans, and anything that has to do with humans, there is that margin of error.
Yeah, that's
Let's
true.
see. Let's see how many people believe in the death penalty. I don't know. When it comes
Why
to
look
kids,
something
I
up? Let me
just
play this. I'm going to play a little bit of the wife's testimony. Watch this. Y'all watch this. And I mean, because it's kind of interesting what she says over here. Here we go. Share screen. Ooh, let me share the screen right quick.
oh
All
shoot,
right.
how many people believe in that? I forgot to put death penalty in here.
Okay, now this is
I
going to
just
be
put how many
it's a
people
long
believe in
crime.
the U.S.
Okay, we're going to play this for just a minute. And this is the wife, the ex-wife. And these were her children. Remember that. Come on now. I need to move it forward a little bit. Here we go. Let's move it a little bit forward so you can actually. Okay,
Towards
that
the
is
end
the
of our
wife.
marriage, I think I was thinking in the best interest for my children, that it was not a good environment. It was not something that children need to be seeing.
Where's the dots at?
So we separated ourselves. Tim initially left me
My
and
dots
turned my
went.
power off and
Wow.
stuff. And we found it really hard because I just had nothing to offer my children. I could not provide for them. I think as a mother, I was making the best choice that I could. I trusted my husband at the time because he gave me no reason not to with my children. He was a good father while we were married. He promised to take care of them. We co-parented pretty good towards the end. I think that's what took me back a little bit. I'm really sorry that everybody has to sit here for this. I don't think anybody saw this coming, and I know between myself
I don't want so
and
small.
members of the Jones family themselves, I know if anybody had seen anything that
Oh, there we go.
any one of us would have done something about it, so we wouldn't be in this position today.
Did you love to?
I did. And I'd be lying if I sat here and said that everything in our marriage is bad. Tim and I had a lot of good times. It just becomes a point when things are volatile that you just make a choice.
Okay, hang on a second. Now, I just want to play that for a minute because she has a lot of remorse, a lot of guilt, that kind of thing. But what did you just hear her say? When things become volatile, well, honey, he's volatile with you. He's volatile with your children. Remember that. So this is kind of disturbing to me. Some of the things she says is kind of disturbing. And I know that she's in a horrible position, that she feels like she could have, this would have never happened if she wouldn't have let him take the kids. But letting him take the kids, she thought she was doing the best thing for them. So she's in a hard position.
Well, and the court awarded him custody for whatever reason.
Right,
So
right.
I don't know how much what lays in the background of that. I haven't dug in that far to see why he was awarded custody
Right.
as opposed to her, what the dynamics were there. If she just didn't have a place for them to go, and that was maybe the bottom line, that he had a home, she didn't, and therefore he got custody. I don't know the details of all that.
I don't know either, and I would like to know, but regardless, I think that there's no way that somebody, I guess I shouldn't have said that, because really there's no way that a person's going to know that if you leave your children with that person that they're going to take their life, because it's so hard to fathom that a parent can take their own child's life. And then when they take all 5 children's lives, all of them,
right?
Family annihilation is just.
I know she had a history of, there was history of abuse between he and her, but
Right.
I didn't hear in her testimony, they never asked her the question that I saw. I didn't finish all of it,
Right.
but I never heard the question answered, was there abuse to the children? So I'm assuming, just because of being a mother, that if there was history of him with abuse with the children, I don't think she would have left them with him, or would have fought the courts if he was granted custody of them. But I never did hear her say that there was a history of violence against the children. I know the one child he did impose, extreme punishment on him, the middle
Right.
son, the one that he ended up running to death. he was always doing what he referred to as PT with the
PT,
child,
right.
making
That's
him run
horrible.
and squat and do all of those things. And I mean that, and that is one of those things in my mind that an abuser can use because it doesn't show any markings. So I'm
You're
sure
right.
there's a lot more to that because you can hide that. You're not going to have
Right.
bruises, you're not going to have cuts, you're not going to have any of that. So I'm sure I mean, I've heard it before in several cases, but those kids, they just went through hell. And like I said, it broke me on the stand when she said, those children loved him. I can't wish for him to die. It's like, oh,
Okay, here's the
yeah,
reason
it
why
says
she had
here,
them. Yeah. You want to go ahead?
go ahead. Oh,
Oh,
I
go
was
ahead.
just going to say, as of the late 2025, a slim majority of the United States favored the death penalty for persons convicted of murder, 52%, making a
Wow.
5-decade low in support. Support has declined significantly from a 80% in 1994, with 44 of Americans now opposing it. Its proponents often include political conservatives and Republicans, 80%. The divide is stark in political affiliation. Roughly 81% of Republicans support the death penalty, compared to a large majority percentage of the Democrats. Support is weaker among younger adults, less than half Americans aged 18 to 54 with the death penalty, with the opposition highest among younger demographics. 64% white, multiracial 65% were more likely to support capital punishment compared to Black Americans at 53%. Support is
Huh.
higher with those with a lower education, 64 to 67%, for those with some college or less, compared to college graduates at 58%, and those with postgraduate degrees at 48%. The
Hmm.
belief that the death penalty is the appropriate punishment for heinous crimes like murder. These is reasons for supporting. Tough on crime, supporters believe it is necessary, albeit sometimes rarely used, a tool for justice and justice for the victims, a belief that it brings closure to the victims. Reasons for declining or opposing. Risk of executing innocents is the number one significant concern driving opposition. A record high 44% of Americans oppose it, often citing it as morally wrong. Fairness concerns that the death penalty is not applied equally across races and regions. Support for the death penalty has become increasingly associated with conservative ideology, while opposition has grown in other groups. That's very
How
interesting
about
to
that?
me.
Okay, I'm going to tell you why he had the kids now. Tim filed for divorce from his wife, Amber, on July 11th, 2012. Following the allegations, the mother had an affair. Okay, so he used that. The divorce was finalized on October 15th. The temporary orders were also issued during the divorce process. One on July 30th, 2012, saying that it was in the best interest of the children that they be placed with the father, and another on April 3rd, 2013. After the fifth child was born, a guardian
But
ad litem.
why? But
She
why?
was
It
pregnant.
didn't say.
Yeah, right. So, in the end, both parties agreed to have joint custody, but the children would be placed primarily with the father. The mother, meanwhile, would have supervised visitation with her children at least every other weekend. Something was going on with that mother. Don't know what it is, but something had to be going on
Just
for that to
because
be.
she had an affair doesn't mean you're a bad mother. And even if she's pregnant with that affair's child,
Right?
that sounds very surface level to me. Very surface level. Like, okay, yeah, that doesn't make sense. Especially with
No.
his history of mental illness and
Right?
abuse. Why was that not brought into the picture?
I don't know.
That's
That's a
weird.
crazy. Yeah, it is weird. But let's talk about her for just a second now. Okay, because I showed a little bit of this. And I mean, we're going to show just about 5 minutes more, but because we already been on like almost 3 hours. It's like 2 hours and 38 minutes. Because in the end, after this happened, like so many other cases, with Harmony, what's her name? I can't remember her last name. Harmony.
Montgomery.
She's
Montgomery.
Harmony Montgomery is another case where the dad had the child, and then guess what happened? The dad's responsible for what happened to her. Then the mother, who did not have custody of the child, goes out and files suit against the state, the state, because they didn't protect her children. Well, that's exactly what this lady did. So I'm going to tell you all about this. Just a minute, I got to pull it back up. So this happened after the deaths on August the 21st, 2024, nearly a decade after her husband, Timothy Jones Jr., murdered their 5 children. A mother will receive $1.5 million from the state. In 2019, Amber Jones' husband was found guilty in the slaying. So let's move on down. And the settlement comes after Amber Jones sued both the South Carolina Department of Social Services and the Lexington County Department of Social Services in 2016, alleging the agencies failed to protect the children from their murder. I don't know how. I don't know if it's their fault.
Yeah, see, I just pulled up her.
Okay, you're making that weird noise.
Her name is Amber. I haven't done anything different.
You sound like you were in a tube for just a minute.
Okay. Yeah, that's weird. She had no job or car when they determined custody. But she did report abuse. She reported abuse of him, but she had no job or car. So that makes a little bit more sense of why they gave the kids to him. Yeah. But
let me ask you something. If he will abuse you, what makes you think he won't abuse your children?
Exactly.
That is so awful to me. I don't know. It's a horrific situation.
I would be terrified.
Yeah.
That something was going to happen to my children. Just because obviously, some people don't think like normal people. So that psycho is going to look at those kids, especially the girls, and what is the first thing he's going to think of?
Yeah, the mother.
He's going to think of the mom. The mother. Right. And so it's like he can't differentiate the fact that that's her or those are her children. There's no line there. So, of course, the risk for abuse is going to be higher.
Okay, I'm going to look at one little thing here. I'm going to see if she ever complained that he, okay. Confessed child killer Tim Jones thought the preacher's wife wanted something. Okay, I'm trying to see if there was any type of, where he ever choked her. Because, sometimes, since he choked them all, I just wonder if maybe at some time they got into a fight and he,
that was his method.
And he choked, right, and that was his method. I just wonder about that too. I have a lot of questions about this story, about these children, about everything that happened right here. But I'm going to have to get off of here because we've been on 2 hours and 42 minutes already. And I'm sorry for breaking down a little bit, but that is hard to read because it's so horrific. Well, just horrific.
He was investigated by South Carolina Department of Social Services multiple times before he murdered his children in 2014. However, I think that was after that he got custody. Because didn't he get custody in like 2011, 2012?
When they first divorced. Yeah, 2012 it was.
2011, 2012, yeah. So after
the fact, child in 2013. So, yeah.
Yeah, so this was, DSS reports from as early as 2011 noted the home was cluttered and messy, though they originally found it was not unsafe. So DSS must have been involved prior to the split or shortly thereafter.
Yeah. Your headphones are
in 2012.
Yeah. Yeah.
Yeah, I'm not doing anything different. I haven't moved.
If you turn your head, I think maybe, I don't know. Anyway, they just kind of get a little bit
No,
weird
I haven't
sometimes.
moved.
But anyway,
Yeah.
he's just a damn monster, and I'm glad that his death penalty was affirmed, and he is awaiting execution. So there you go. He will not be let out. He will not pass go. He will not get $200. He will proceed on to the death of whatever choice that the South Carolina uses. So there you go. I wanted to play the oral arguments, but I couldn't find it today. I'm like, oh my God, I found it yesterday, but today I couldn't find it anywhere. I'm like, shit. So I decided, well, we'll just go ahead and read the opinion and just go like that. But this case, there's not another one like it. You know, the South Carolina appeal judges were saying there's nothing to compare it to. There's not another one to compare it to. I mean, 5 children. But now let's talk about Lindsay Clancy for a second, because we are going to cover Lindsay Clancy. She's also a family annihilator. She has decided that she is going to probably plead guilty by reason of insanity, and it'll be another one of those bifurcated trials. Oh God, it'll be the same thing, because she is facing the death penalty as well. So that's another trial that's going to be kind of interesting.
The only one that
Why?
comes to mind when you say the 5 children wasn't her name Andrea Yates? Isn't she the one
Oh
that drowned
God,
all
yeah,
5 of
Andrea
her
Yates.
kids?
She did drown
And
her
she's
children. Sure did. Yeah.
been in but she's been in a mental hospital since the crime, and she was found insane. You know, I think she was one of the I think she
Let's
was
see.
one of the first for postpartum depression.
Okay.
I mean, not the first person, but of course, publicly the first that, she was found guilty by reason of insanity. But if I remember correctly, I mean, those kids were back to back to back to back to back, and they lived in a small mobile home trailer. And, I mean, this was 2002. Just she had postpartum psychosis and schizophrenia, and she's always been in a mental institution, as of where she should be. You know,
Right. Well,
you
because
might
go ahead.
go ahead. No, I was gonna say
No,
you might recover. They might be able to stabilize your mental health, but when you come to normal mental health and you realize what you did to your children, that's a whole nother story. So you're never going to be able to function normally.
right.
You know what I
I
mean?
think so
It's never
too.
going to happen. It's never going to
Well,
happen. Can you
he was
imagine, like, having to live with that, regardless of that? Would drive me insane. I mean, that literally would drive me insane. I wouldn't be able
well,
to
the
handle
first time around she was given life in prison, but then it was overturned by some false testimony by a prosecution witness, a forensic psychiatrist, Part D. So we're going to have to look at this now. We're going to have to look at it. Okay, y'all, we're going to have to refresh and look at this one. But in 2006, a jury found that they retried her, and she was found not guilty by reason of insanity. And that's when she was moved to North Texas to the state hospital. So now I want to relook at this, because I did not realize that she had been overturned, and for
I
some
didn't
reason, I thought she was
either.
always in the state hospital. That's what I
I did
thought.
too. I thought
Wow.
so.
Okay. Well, let's see what we can pull up and do it, because it was postpartum psychosis and schizophrenia. So there you go.
By a prosecution witness, forensic psychiatrist. I never
Can
knew
you
that
believe
either.
that?
That's interesting.
Wow. False testimony. In a case
Wow.
like that, what in the hell? Craziness there. Anyway, okay, we've been on 2 hours and 47 minutes. I'm gonna have to get off of here. I got some things I got to do before my child comes over this afternoon to pick up a suitcase. We talked about that situation. Oh my Lord.
Yeah.
Anyway, I'm just nervous.
Yeah,
But
I know,
anyway,
Mama. My mama heart is with you. You know that.
yeah, I know. They grow their wings and they fly away. We know that. But
I know.
damn, child, you could have just went
But
to
we are,
Texas on vacation.
yeah, but we as mothers who've lost children, we are very jaded. Like I told you
That's true.
earlier, we are very
Yeah.
jaded, and we look at a normal situation where if you didn't lose a child, how another mother would look at that situation. We look at it very different. And we always, in our minds, anything that happens, we always say, I can't bury another child. You know,
And,
it's
and
just
especially, yeah,
it's just what
it's
it
just
is.
there.
Unfortunately,
It's always going
yeah.
to be there. It's never going away.
Mhm.
I mean, he could be
Mhm.
across town at his college apartment, and if I think something's wrong, you know, you might panic. So I don't know.
And
It's just
like
something
you
that
s-
happens. It's within us.
and
So.
like you said earlier, the further they are away,
Oh
even if
yeah,
they're not doing anything, even if
yeah.
they're just say he moved, you know, 10 hours away, 15 hours away, 20 hours away. Just
You
the
know, I'm
fact
moving
that
too.
you're
Then
not
right.
close, yeah, just the
Yeah,
fact that
yeah.
you're not close to them, not that in case something would happen, we would be able to do anything. It's just that distance factor. The fact that
Right.
we can't get there quickly is another level to it all. It
It,
adds
it
another
is.
level to it. It really does.
So I'm not going to be able to come live tomorrow because I got to go. We got to go look at houses. That's a whole another story I'll have to tell you about. So anyway, it'll probably be Saturday or Sunday. But we'll probably do it at night. We'll probably do Saturday night. But I want to do something. We might look at Andrew Yates. I'm not sure what we're going to look at, but we're going to look at another insane, not insane death row case. So with that, y'all have a wonderful afternoon. Stay safe out there, and
Hug your babies.
that is damn right, because life's short and your time with them is even shorter. And I say that every time because it's so damn important. They are our number one concern. Anyway, we'll see y'all later. Y'all have a good evening. Bye.
Bye, everybody.
Have fun. All right, good.